Good morning, everybody. Happy Monday. Welcome to TCF Live. Good to have you here. Let's start our week out with Judge McNally, where he's got a small game of Hollywood Squares going this morning.
It's good luck to you. Oh, wait. And you got another one here, Mr. Lightberg. You've held this since October. This is on B1, hang on, B1495818. You got defaulted. I gave you till January 28th to pay. I want to make sure that Heather or somebody's on there, Jennifer or Linda, please. They're going to have to.
You want me to give Heather a call and have her jump on?
Yeah, please.
Sure.
Tell me when, is Heather on there yet?
All right.
Just tell her to take a good look at these Ligber files. I want to make sure.
Bring her in.
She's jumping in right now, Your Honor.
Heather, on this Jesse Andrew Ligber, I've got a 25B149581A. I'm giving him until April 1 to pay that. April 1 to pay that one. And then on the other file, 25B149581B, that's the misdemeanor. I'm extending his probation by 2 months until June the 3rd. He has to pay additional probation fees of $40, and he's to pay $100 per week, beginning February 16th, with all money due by May 1 of 26. I'm going to send it down. Just take a good look at both of those citations for me, okay? But that's the changes. I want to make sure that they didn't go unnoticed, all right?
Okay, Judge.
Thank you. Epic Property versus Jillian Carroll and Ryan Carroll, 2600141. Good morning, Mr. Cox.
Good morning, Your Honor. Pleasure to see you, Judge Aaron Cox. I'm appearing on behalf of the plaintiff.
Do I have Jillian Carroll here? And do I have Ryan Carroll here?
Neither one have checked in, Your Honor.
All right, and this was scheduled for 8:30, and they paid for a second mailing. You can go ahead and proceed with your default, Mr. Cox.
Thank you, Your Honor. Due to the defendant's failure to appear, we are asking the court to enter a default possession-only judgment at this time. The rent to retain is $838. There are court costs of $223.56.
Your breakdown with your late fees, please.
I can, Judge. Filing fee is $55. Service fee is $65.13. The court mailing fee is $26. The statutory attorney fee is $75. And then the e-filing fee is $2.43.
About the late fees.
Oh, yep, sure, Judge. Yep. The late fees that we are seeking at this time are $50, Judge.
50 total?
Yep, 50 total.
So you have past due rent of $788, late fees of 50, total 838. Plus you have $223, so it should be 1,061. Am I right?
Judge, I've got 56 cents in between. There's a 13-cent amount on the service fee and then a 43-cent amount on
Yeah, thousands. I didn't have those. 1,061.56. Is that right?
That's correct, Your Honor.
Writ date will be on the 12th. I'm going to ask you to get that to me as soon as you can this morning, okay?
No problem, Your Honor.
Epic versus Canaz Lawson and Lenina Shields, 2600142.
Good morning again, Judge Aaron Cox, appearing on behalf of the plaintiff.
I don't see either one of them.
No, neither party checked in, Your Honor.
Go ahead. Give me your breakdown, if you would, counsel. Start with rent to retain, please.
Your Honor, the rent to retain at this time is $1,933.14. We have court costs of $200.
What about late fees?
I'm pulling them up right now, Your Honor. Judge, it's $50 per month for 2 months.
So it's 1833.14 plus 100, and your total court costs?
$223.56.
All right, 1923, 1123, 1146.70, right?
That's correct, Your Honor.
Writ date will be 2/12. I still want to thank those nuns, Mr. Cox. They pounded additions, subtractions, and thanks to, the nuns, it's addition, subtraction, multiplication, division. Anyway, writ date will be the 12th, fault judgment. Epic versus Latasha Norris, 2600143. Is Norris here? All right.
Your Honor, she did not check in.
Thank you. Default judgment will enter. You can tell me your rent to retain only, then late fees, please.
Your Honor, the rent to retain is $1,524.40. We do have $100 in late fees. That's $50 per month for 2 months. The total rent to retain with late fees is $1,624.40. We have court costs of $184.17. The total is $1,808.57.
Defendant failed to appear. I thought you said 1524.46.
Just 40, Judge.
Oh, 40. Okay, I'm sorry. 1808.57. Writ date will be on the 12th of February. I'll again ask you to submit that judgment this morning, if you would, please. Epic versus Lauren Singer, 2600144.
Your Honor, she did not check in.
Okay, you can go ahead and proceed with your default.
Thank you, Your Honor. At this time, we are seeking a rent to retain of $4,032.91. There are late fees of $100. That is $50 per month for 2 months. The total is $4,132.91. We have court costs of $184.17 for a total judgment of $4,317.08.
Defendant failed to appear. Default judgment is entered. Writ date will be February the 12th. The amount to be paid to save it is 431708. Is that it, or do you have Progressive? Progressive Housing versus Jamie Rose and Michael Rose Jr., 2600148. Good morning, Mr. Rose. Your appearance, please. You have to unmute. There you go.
Okay.
Name,
Michael Rose.
where's Jamie at?
I don't know, sir.
Is that, what relationship is Jamie with you?
She's my wife.
Are you guys still married?
We are.
She still live there?
She does, but we're separated right now. So I think she's with her mom. I'm not sure.
All right. Did you listen to and understand the rights on the rights form, the video?
Yes, I did.
You wish to speak to a lawyer?
I'm not sure on that right now, but I'm gonna try to get assistance.
Okay, so you intend to apply for funding?
Yeah, I do. Yes.
All right, I'm going to adjourn this. Mr. Cox, your name?
Your Honor, Aaron Cox, appearing on behalf of the plaintiff.
So you're entitled to a 2-week adjournment. You have to get your proof that you've applied for funding to us within 5 days. Okay, sir?
Okay.
So you'll have to bring that up to the courthouse. What are we doing on this, Jennifer? Or you don't have to be in here now, Heather. I just wanted you in here on that one case. Jennifer, what day am I doing that week? The 16th is
Judge, the 16th is actually a holiday. We won't be here. So we could push this to the 23rd if you'd like.
Yeah, we'll do the 23rd at what time?
About 8:30.
8:30. Okay, so make sure you get that up here, sir. And you understood all your rights, correct?
I do.
All right. If Jamie has any interest in being there, you should tell her to come to this, okay? The next hearing date, all right?
You said the 23rd
Correct.
at 8:30?
Yes, sir.
Okay.
All right, good luck.
All right,
Thanks.
thank you.
Red Hawk.
Good morning once again, everybody. Happy Monday. Welcome to TCF Live. It is mostly a civil issue Monday out there in Courtlandia. That is what almost every court is covering. However, it looks like Judge Elmore, who's in Missaukee County this morning, is about to start a more criminal proceeding. So let's head over there.
Hi, folks. Good morning. We are on the record today for the 28th Circuit Court here in Missaukee County. And we took care of a pretrial conference earlier off the record. So now we're moving to our docket call. And our first case today on the docket is People of the State of Michigan versus Tiffany Kathleen Jacobson. This is file number 25-3606FH. Appearances from counsel. Begin with the prosecutor, please.
Thank you very much, Your Honor. Attorney Robert Ringstrom, Assistant Prosecutor for Missaukee County.
Good morning, Your Honor. Allison Castle on behalf of Mr. Jacob or Miss Jacobson.
Good morning,
Thank
Your
you.
Honor. Lisa Kirsch-Satawa, also on behalf of Ms. Jacobson.
Thank you. Both counsel for the defense are appearing this morning via Zoom with permission by the court, and also join us this morning via Zoom from a Department of Corrections facility is Ms. Jacobson. Ms. Jacobson, are you able to see and hear the court?
Yes, Your Honor.
All right, thank you. Ms. Jacobson, again, I remind you that you have the right to be physically present in the courtroom, but it's my understanding that you waive that and are allowing us to conduct today's sentencing via Zoom. Is that correct?
Yes, Your Honor.
Thank you. Any objection to that, Ms. Castles?
No, Your Honor.
Also here this morning is Mr. Luke Blazak. He is the agent from the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. Let's begin with the prosecutor. Mr. Ringstrom, do you have any amendments, corrections, or objections to make?
I have had a chance to be able to review the report. I personally do not have any amendments or corrections. I do understand that OB 12 probably should be scored less though.
Okay, so by the way, while we're waiting for you guys to come in, he told me you just had two challenges. So let's go ahead and talk about the first one. Ms. Castle, you're challenging offense variable number 12, as I understand.
Yes, as it relates to both offenses, offense variable 12 is for the contemporaneous felonious acts. In doing their calculations, probation calculated this based on possession of methamphetamine, felony firearm, and carrying concealed weapon. MCL 777.42 excludes felony firearms for being counted on for this variable. So as a matter of statute, we believe that should have been properly scored as a 1 rather than 10.
All right, thank you. And Mr. Ringstrom, your response, sir?
I really don't have any objections to that, Your Honor. The possession of meth was what she had pled to was a lesser included of that, and I do know felony firearm can't be used. So
Okay.
I personally don't have any objections to it, and having it scored as 1 is okay.
All right. All right, thank you. All right, the court will grant that objection or challenge. We will therefore reduce offense variable 12 from 10 points to 1. And that's going to modify the total OV points for the first count, which is weapons firearm possession as a third habitual offender. That will reduce it down to 11 points. And I know there's going to be more. Just a moment, though. So that in and of itself would not change the OV level. Then we're going to look at count 2, which is the delivery, and that is going to modify OV 12 again from 10 to 1, and that will reduce the total offense variable scoring from 25 down to 16. And that offense, that would go down from a category, an OV level 3 down to an OV level 2 thus far. All right, Ms. Castle, your next challenge.
Next challenge is to the scoring of offense variable 14, the offender's role in the situation. Ms. Jacobson was scored 10 points, indicating that she was the leader in a multiple offender situation. Well, we don't dispute that there can be more than one leader. That's not what happened in this situation. The People v. Hayes is a Court of Appeals case decided in May of 2023, through which the court remanded for resentencing, where the defendant was scored as the leader under this variable, but his actions didn't show by preponderance of the evidence that he guided, directed, or otherwise was a primary, causal, or coordinating agent in the criminal transaction. That's what happened here as well. Ms. Jacobson was not a leader in the situation. The co-defendant, Miss White, was. Ms. Jacobson testified against the leader of this incident at the prosecutor's request. As she testified at trial and informed the police, she wasn't working with Molly White. She didn't provide Miss White with any controlled substances or help her to obtain them. The only basis for calling Ms. Jacobson a leader is that she was driving the vehicle. It was her car, and so it makes sense that she would be the driver. She did not learn about Miss White's intentions of selling controlled substances until she was in prison and heard this from another inmate who was the intended recipient. But Miss Jacobson had no information, and I don't believe that there is a preponderance of evidence to establish that she's any degree of leader in this situation.
So far, that it seems like a lot of that is going as to count 2. Let's talk a little bit though about count 1, which is the felony firearm. Mr. Ringstrom,
Yes,
let's
sure.
focus on that portion first. Go ahead.
We can focus on that portion as far as the felony firearm first, Your Honor. She is the one who had possession of the gun. She admitted it was her gun. Not that it really matters as far as it goes, but it was a loaded gun at that point in time and did have 2 bullets that were in it at that time. At the time of the pullover, she wound up passing that gun back to one of the passengers, Austin Ware, and basically told him, hey, hide this and everything. At the time, Austin Ware was actually charged with a felony firearm also because he was the one who had the gun and all of that stuff. So for those purposes, I do think that she would be considered a leader in that regard, because there was 2 people that were originally charged with it. It was her gun. She's the one who passed it back to him.
All right, thank you. Let's focus on that first argument. Ms. Castle, you kind of talked about the second count. Let's talk about count 1 though first, regarding the firearm.
Between those two, the passing back following Mr. Ringstrom's theory of how the case occurred, passing it back, there's no indication that she was the one who loaded or that she knew that it was loaded. Notably, when police encountered her, it was not physically in her possession. It was under a seat, I believe. I don't think that is enough to say that she's the leader of this multiple offender situation, as the facts don't support that to a preponderance standard.
Mr. Ringstrom, she admitted to having the firearm and turning around and passing it back to somebody else, correct?
She wound up, I believe she admitted that at her plea process, that it was her gun, that she knew it was there and all of that. And
I remember her testimony. She did a very good job testifying. So, all right, the only thing here is when I look at it, was she a leader, or did she just pass it back to a guy? I wasn't in the vehicle. No one here was, except for the defendant, was in the vehicle. Was she merely trying to hide evidence? Maybe. I think that's probably the best thing we could interpret. She definitely knew about the firearm. I don't buy the argument that she didn't know it was loaded. I mean, it was her firearm. So yeah, I don't buy that at all. Of course, why she was driving with a loaded firearm, unlawful, in a vehicle, carrying concealed, those are probably different arguments, and that I can take into consideration when I establish my sentence. So at least for count 1, I'm going to go and change that from 10 points down to 0 for OB 14. That's going to bring total points down from 11 to 1. That'll bring the OB level down from 2 to 1. And that makes the guideline range dip just a little bit from 12 to 36 as a half third down to a 9 to 34. Plus, we're going to be conservative and eliminate any appellate issue there. So now we're going to turn to count 2, and this is the delivery and whether or not she was or wasn't a leader there. Now, this is where Ms. Castle began her argument. I think she's already covered it. Mr. Ringstrom, go ahead on your response to that portion.
It was her vehicle. She was the one who was driving it. Testimony at the trial, which the judge heard.
Yeah.
They were all smoking it in the car and all that stuff. Ms. Jacobson admitted basically that she knew what was going on. And there was actually more than just possession, it seemed. It seemed like there was delivery going on as well.
And she testified that she was there when Miss White was on the telephone and said, hey, we need to go here, drive me here to go get the meth. So,
yes. So I believe all of that could establish that she was a leader along with Molly White. But
yeah, I mean, the other guys, the 2 gentlemen in the back seat, they were just along for the ride, getting high and going to the store. Ms. Castle, anything to further say there in response?
I would just further state that her lack of knowledge in actually putting this all together for purposes of delivery. Yes, she was aware of the drugs in the car, but was she aware of Molly's plan to and then deliver it? Is being I believe that her being present while Molly was on the phone is insufficient to say that she was a leader, as Miss Jacobson wasn't on the phone. She wasn't aware of who she was speaking to. That's where that nexus is. It's not strong enough to say that she was a leader.
Can you become a leader by accessory in the middle when she found out? Because what she testified to was Molly was on the phone. Molly told her, we need to go here to go pick up more for deliveries. She testified that Molly told her what she was doing. And so then Molly only could have gotten there if Miss Jacobs had driven her car with Molly to the place to go pick it up. Isn't that a lot like a driver in a drive-by?
I think of that more as her being led. She was led to drive. She was taking
How was she
direction.
led? Yeah, she's the one that had the gun. So how was she being led to drive? Did Molly White say, do it now or I'll hurt you? She just said, hey, turn the steering wheel to the right. And then Miss Jacobson turned it to the right. She couldn't have gotten there. She could have said no. She could have, because she didn't know Molly, is what she said. Miss Jacobson her testimony was very open. I thought she did a very good job testifying. She came across very believably. All right, so hold on. Let me just take a look here for a moment. Is the habitual only as to, that's only as to the count 1, correct?
Yes.
All right, thank you. So, but what I'm going to do is eliminate any appellate issue as to the scoring. I think the argument isn't the winner, but I'll grant it to eliminate that appellate issue. Therefore, that's going to reduce offense variable 14 from 10 to 0. Again, I don't buy the argument, but I'm going to do it by eliminating, looking forward down the road and eliminating that potential appellate issue, which again, I don't think is a winner, but I'll still do it. Therefore, we are now reduce the total EOB points from 16 down to 6. That changes the offense variable level now from the 2 that we had previously down to a 1. And that's going to give us a sentencing range of 9 to 23, according to the guidelines. All right, Ms. Castle, any other challenges to any other part of the PSI?
No other challenges.
I'm sorry, no, you go ahead. I know.
No other challenges, just some factual corrections.
All right, thank you. Mr. Ringstrom, before you say it, I'm going to say it. We need to change the date on the page 2 or page 1 of CFJ 145. Plus, and she's currently serving a sentence. So while we would have to make an amendment on CFJ 145 page 2 under the jail credit section, that would change that end date from January 5th to January 5th to February 2nd. But again, The credit is 0, but I do think it's worth noting that the parenthetical of the 101 days, that's going to have to be changed to 128. Nobody criticized me if I did my math wrong. Well, you can criticize me if I did not do math well. But I think it's 128 days now. Okay. All right, Mr. Ringstrom, any other corrections, amendments, or challenges to make to the contents?
No, Your Honor.
All right, thank you. Ms. Castle, now you said you had some factual allegations or concerns. Go ahead.
Just really quick about to make a correction about her credit. It's my understanding that the prison sentence terminated on the 5th, so she would have been entitled to credit from the 5th to today.
Okay. Well, actually, no, because did she enter? Hold on. I don't remember when she entered her plea. Just a second. Actually, if she entered her plea on November 14th, well, but she's already serving a sentence. So how does she get credit when she's serving a sentence? I can take it into consideration. I'll agree with that. But I don't think she gets dates or time toward credit.
My understanding was that she completed her prison sentence on January 5th, so the time interim from now to then.
I'm sorry, I missed that. You did say that. Mr. Blazak, did she finish her sentence?
It's my understanding that she's still in prison.
Well, I know she is. I can see her. But
so she would have.
If she had completed her sentence, she would have had to have been brought back here to Missaukee County Jail, because there wouldn't be any lawful detention of her in the prison system.
Yeah, I'm not aware that they would hold her for.
Let's take a quick look here at CFJ 284 section. And 1 second. So she was sentenced on September 26th of 2025. Do that right. 1 second. Sorry. Well, it'd be really close. She would have to have had she'd have to serve the minimum of 14 months.
That would be her earliest potential release date.
Yeah, but if she had 314 days credit as of the sentencing date on September 26th, she would have earned another 400 and I'm sorry, she would have earned another 96 days. Is that right? Yeah, 96 days. So that's 410. That would give us roughly 13 and a half months. So what I don't know is I don't know what the parole board did. Did they release her? Did they grant her? I don't know. So here's what I'll do. I'll leave it up to the defense or somebody to file a motion to modify an unlawful or invalid sentence if they get me proof that she actually was released by the Department of Corrections. Likely she may have been, but if she had been, there's no way she could, I don't know how she would be able to be in prison. Oh, Miss White, I'm sorry, Miss Jacobson, you got your hand raised. If there's something you wish.
Your Honor, I'm sitting on a deferral right now. My ASAT class, I just finished my midterm with all perfect attendance and all assignments all correct. And I get off on the second week of February.
Okay, so you haven't done, thus far, you have not finished that sentence, is that right?
I finished the sentence. My parole class is over the second week of February, and that's when I'm completely done just with my class. So everything's done, just my class ends on the second week of February.
I think I understand them. So the point is, she's still serving a sentence.
That's correct.
Defense can make that argument for the court to take into consideration, which I'm able to. But whether or not she actually is entitled to credit, I don't think she is. All right, next, Ms. Castle. You said you had other factual.
Yes, yep, I do.
challenges.
I'm just trying to get notes back together.
Okay.
Under the personal history section of the first page, CFJ 145-1109, under personal history, it states that she's unemployed. She was employed as an in-home healthcare aide for her mother-in-law at the time that she was arrested. Upon release, she'll go back to this role.
Mr. Blazak, does it need to be changed, or technically she's unemployed, but she's, maybe you call it, she's on vacation, or I don't know, permissive leave. I don't know what the right phrase would be, but
It says,
yeah, I mean, I right now she's not employed, because, like, for instance, you could have somebody who is here for sentencing who wasn't in confinement, was on bond, and was employed. But right now, so I'll leave it as unemployed, but again, Ms. Castle, making that argument is a good argument for me to take into consideration. Again, when you look at the PSI program that they use, there are only so many choices they have. I can tell you that sometimes I wish they had an other, and you can type in, but all right, thank you. You may continue. Next.
Yes, I'm sorry.
I would say I believe that's all. Aside from just corrections to the credit to reflect the time that's lapsed, since if the court's willing to consider that, if not, that can just be reserved for argument during allocution.
Yeah, that we're just going to leave that reserved for argument. Again, I can take that into consideration. Whether or not it is required to be counted as credit is a different question, and I rule that it is not. All right, allocution then, Ms. Castle.
Since Ms. Jacobson's initial interaction with law enforcement for this case, she's been entirely cooperative and taken accountability for her actions. She consented to the search of her vehicle, answered everything that the police officers asked her, and didn't give them any trouble otherwise. While in MDOC, she's had no tickets, no warnings, or otherwise any reprimand, and her pattern of cooperation continued as she willingly agreed to testify against the co-defendant about what really happened in this case. If the court's inclined to max Ms. Jacobson out at the top of her guidelines, she would be staying in prison with the people or with the person whom she testified against, and with there only being one women's prison in Michigan, her safety is a serious concern. Based on the sentencing guidelines, Ms. Jacobson is eligible for any additional custody ordered to be served in county jail, and Ms. Jacobson deserves this opportunity. While this case has been pending, she's been actively involved in rehabilitation and making life-changing improvements. She's made great progress with her ASAP program, as she mentioned. It's a 3.5-month intensive substance abuse class. She's had perfect attendance there, no tardies and no reprimand. She's also been working in the kitchen while at the prison, and she's additionally been trying to work towards getting her GED. But if she were to be released very soon, then she's also paid tuition for an outside GED program, not through the correctional system. Prior to arrest, she was the full-time live-in caretaker for her mother-in-law, who has been present at all of Ms. Jacobson's prior court proceedings. Her mother-in-law has a variety of serious ailments and relies on an oxygen tank and Ms. Jacobson's care to survive. By sentencing Ms. Jacobson to a term at the county jail, her mother-in-law would be able to see her and continue offer her support to Ms. Jacobson as she continues to succeed through sobriety and making these substantive improvements. Ms. Jacobson has been clean from drugs for over 9 months now, and she has no intention of going back to that lifestyle. She intends to continue with her treatment and remain sober as she understands the negative impact that drugs have had on her life and the consequences that they bring. She advised me when we spoke about her PSI that a family member has been calling to get her involved in inpatient residential treatment following her release. If she's able to secure a bed at a residential treatment facility, we would ask that she be allowed to be released from custody into this treatment program to continue her progress. And upon release, Ms. Jacobson will have or will still actively be working towards her GED and intends to care for her mother-in-law for as long as she needs. She'll also have housing through her mother-in-law. So we're just asking that she be sentenced to the low end of the guidelines due to her cooperation with law enforcement and the steps that she's taken to not come before the court again in the future. If the court is willing to sentence her to a term of house arrest with GPS monitoring and any other conditions needed to ensure community safety and her compliance with conditions, this would allow her to resume providing care to her mother-in-law. But if the court's unwilling to allow this, we would ask that Ms. Jacobson be sentenced to a short term at the low end of the guidelines at the Missaukee County Jail.
Thank you. Mr. Ringstrom?
Well, I agree that after Ms. Jacobson got caught, she has been very cooperative. I agree that after she got caught, she has been doing all the services that is being stated and all of that stuff. I agree that she did testify for prosecution, that she, like Your Honor said, I believe she tested very honest. I believe that she did a really good job with her testimony. I believe that her testimony would have wound up potentially even supporting a delivery of meth instead, but that's besides the point. For that testimony, she got a really good plea bargain here as well. And that was something that we had considered at that time. I agree with all of that stuff. Ms. Jacobson, since she has got caught, has been doing a phenomenal job. She was still carrying around a loaded gun while delivering meth and all of that stuff, which is something that I don't think our society really likes as a whole. I'm going to leave it up to the court as far as this decision, as far as what to do. I also agree, and I don't remember Ms. Castles had said it or not, but January 5th, she was supposed to have been sentenced and was unable to be sentenced because the attorneys had not got a hold of her. And that should have been brought up as far as some time that this court should consider as far as being less.
All right, thank you. 1 second. All right, Ms. Jacobson, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say?
Yes, Your Honor. I humbly come before you to express my sincere remorse and my commitment to change. There's no excuse for what I did was wrong. I'm truly sorry. I'm sorry to my family for leaving them with my responsibilities because of the choices I made. I want to make it right and make amends, and I'm willing to do whatever it takes to make this happen and be reunited with my family. I've worked diligently each day of my incarceration, preparing for success upon re-entry. I've developed new healthy habits and have a new mindset focused on future goals that I've created in alignment with my values so that I may earn my freedom and reunite to society with my dignity intact. That includes my ASAP, my Suboxone program, and my classes and working in the kitchen. I'm able to come clean and admit my wrongs and begin making amends. I take this very seriously. I've secured housing, unemployment, and have supports in place. I'm 100% committed to putting safety first and obeying the law. I will continue taking incremental action steps while remaining in recovery so I can change, so I can be the change I deserve to be.
All right, thank you, Ms. Jacobson. One of the interesting things about being a judge after having been a prosecutor and a defense attorney is that I no longer represent either party, obviously. And it's now finally when we get to sentencing that a judge applies his or her discretion. And in trying to reach a sentence, there are a lot of factors that I take, in addition to those that are argued by the attorneys. First, I'm going to compliment you, as I already did earlier. You came in here during the trial with Ms. White. You were here without having counsel present, and you testified very credibly and very openly and thoroughly. And so the concept of taking it on the chin, you've done that. You admitted up to your errors, your bad choices here, and I welcome that. And the comments that you've made today stand out to me, believe it or not. Not a lot of people involved with this kind of criminal history and involved in this demonstrate to me what I really believe to be a sincere position, a sincere understanding, a sincere acceptance of responsibility. Normally, I just get the desperation. And so I compliment you on that. On the other side, there are a lot of factors. You know, not only were you not only were you carrying a concealed weapon, you were carrying a loaded weapon inside of a car, which is an unlawful transport. So there's another misdemeanor that you saved yourself from, the CCW, a felony. Plus you were operating while under the influence, putting everybody on that roadway in danger. You were smoking meth at the time. Everyone in the vehicle was handing the pipes or whatever it was, I forget now, back and forth. So there are at least 2 misdemeanors and another felony out there. Now, I know the felony was taken into consideration for OV-12. I got that. But I'm just highlighting that in addition to that OV-12, there were multiple offenses. I'll also note that had you been convicted at a trial for a Class B of delivery of meth, the minimum guidelines would have been at least 72 to 180. That is a presumptive prison sentence. So by doing what you've done, by working with your through your counsel with the prosecutor's office, you've done a very good job of bringing the maximum down from 480 months down to 120. Am I right? No, 50, 60. Sorry, there we go. And bringing the minimum guideline range down from easily what would have been 10 years down to a guideline range somewhere right around, hovering right around a 1-year sentence. So you've gotten a significant benefit here, and I appreciate that. Again, I appreciate what you had to do to get that. One moment. Actually, was it a 4th habitual offender or was it a 3rd? Actually, if it was a 4th, yeah, it was a 4th. Brought it down from, yeah, you brought it down from life.
She was charged with possession.
Yeah.
We didn't have any evidence of delivery at that time.
Which changes that guideline range from the 72 to 180, from 72 to 240. You've done a really good job here, taking it on chin, and you've also got a significant benefit. And you've been doing a lot of the right things at the prison. Now, the others, on the other side, I'll have to tell you that, you know, I speak at public events, or I write articles, or I participate in panel discussions. And the number one concern that every citizen raises to me is this. You have this whole incident here was, other than sexual assault charges involving children, this is the number one concern for every resident in Wexford and Missaukee County. Driving, drinking and driving, but this one was driving while inhaling meth, rolling around with loaded guns, and delivery of controlled substances. So this is at the top of all the concerns for the people of this county. I hear it every time I talk to people about what's going on in the courts. Now, at the same time here, you've had a history. It's not overly extensive, but for a person who's 35, and there's a fairly significant amount. And it really kicked in the most, I think, in the last 5 or 6 years. That's when, you had 2019, you had the assault and resist the police officer. While on bond for that, you picked up a delivery charge, which was reduced down to a possession. And then while you were 9 months after being released from probation, you picked up another meth case. And while you were on probation for that, you made it about 7 months before you picked up another methamphetamine charge. And you picked up actually 2 probation violations in that file. Meantime, you had an unlawful use of a motor vehicle going on. Then entry number 9 of 11, that's when you picked up, while on bond, a receiving and concealing stolen property. There you also violated probation. Then 2023, while on probation, you picked up another larceny charge. And I'm going to tell you, one of the things that stuck out to me is there are multiple, they weren't drug charges, they're typically property cases. You had an embezzlement as a juvenile. You had 1, 2 different retail frauds, plus the receiving and concealing, plus the unlawful use of a motor vehicle in 2022, plus in 2023, another theft case. And then you pick up this case. And you picked up this case while on probation. So there's a balance here, and I've got to figure out what the right balance is. And again, I commend you that I believe you. I think you've gotten some corrective measures here. So let's focus on those positives. All right, one moment here. All right, the sentence of the court is as follows. The court sentences the defendant with 2 $68 state minimum fees, a $130 crime victims' right fund fee. And I'm not going to assess any costs, and I typically do even for those that are in prison, because I'll make payment of those conditional for parole. I'm not going to assess any fines based upon the same concept. I will, however, assess a $300 attorney fee. There is no DNA fee here because DNA was clearly already available. As to count 1, the weapons firearm, the court does, within the discretion, exercise to sentence the defendant as a 3rd habitual felony offender. However, I am going to sentence, while I'm going to sentence the defendant to a prison term, it's going to be toward the bottom of those guidelines. So for this count, the court sentences the defendant to, I'm going to say 13. And then what I'm also doing here for the record is I'm taking into consideration that she's been sitting in jail or prison, even though she's not entitled to credit. I think what I'm doing is recognizing that and reducing it a couple months just in my mind. And so I think I'm already doing that. So that is 13 to 120 months. And the defendant receives the 154 days of credit. As to count 2, which is the delivery, anybody helping deliver drugs, you've got to expect a prison sentence. If you score a prison sentence, you're going to get a prison sentence here generally. I'm not saying I don't take in other factors in consideration, but that is the #1 concern for most of the citizens in these 2 counties: delivery of drugs. 66% of my caseload is criminal, and of that 66, 2/3 of it, another 66, are just methamphetamine. So that's it. So here the court is going, and I'm recognizing the fact that this is the methamphetamine. and the court sentences the defendant to a range of 15 to 60 months, again with 154 days of credit. Have I missed anything, Mr. Van? Sorry, not Mr. Van. Mr. Van Amel, you are Mr. Blazak. Did I miss anything, sir?
Just clarification, I guess, whether those are concurrent or consecutive.
Oh, sorry. Yes, they run concurrent. Thank you. I apologize. I didn't mention that. They run consecutive to whatever sentence she has left to serve that's keeping her in the prison right now. All right. So again, count one, 13 to 120, exercising the discretion to sentence as a third habitual offender. As to count two, it's 15 to 60. There is no habitual enhancement there, and each one she gets 154 days of credit. Mr. Ringstrom, any questions, or do you believe I missed anything?
No, Your Honor, I think you got everything.
All right, thank you. All right, Ms. Castle, is there anything you think I've missed?
No, Your Honor.
All right, thank you very much. All right, Ms. Jacobson, you will receive there at the prison 2 copies of one document. This document is entitled at the top, your notice of right to appellate review. You have the right to appeal the conviction and sentence. However, based upon the fact that there was a plea of guilty, any appeal must be done by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, if you do choose to file an appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of that document that will be provided to you and return to the court within 42 days. All right. Anything else, Ms. Castle?
No, Your Honor.
Sorry, Ms. Satawa, you took off your mute. Go ahead.
I did, Your Honor. I just wanted to place on the record that Ms. Castles did visit Ms. Jacobson in person and reviewed the PSI in order to ensure its accuracy. I don't believe that that was placed on the record.
Oh, no, and thank you very much. I appreciate that. I think it's always a good thing for counsel to comment upon. All right. Well, I've given a sentence that does involve a prison sentence. It is at the bottom end of toward the bottom half of the guidelines, which I think because of how she's handled this case, how she's dealt with the prosecutor's office, the police, how she's helped resolve the other cases, she has saved herself easily another 5 to 6 years. That may be something that's lost. I want to highlight that. The next thing is Ms. Jacobson, you may not feel it, but trust me, all right, maybe besides Ms. Castles, you're a lot younger than everybody else here involved in this case. So you got a lot of life to live. And that's what I'm trying to get to, is the positive. You may not feel it now. That's the positive. You would have been sitting there until you were probably 42. But you'll be out well before that. You've got a lot of opportunity, maybe to come back here to the community, maybe and be a peer recovery coach, things like that. There's a lot of ways to look at this, and turning it into a positive as a learning lesson is what I really hope that you do. I really hope that we never see you here in a jumpsuit, but I do hope that you're always welcome to come by and chat. I have coffee with people on occasion, and I always like to hear about positivity. So that's what I want to turn this into, positive. All right, thank you, folks. We are adjourned.
Thank you.
Good morning once again, everybody. Happy Monday. Thank you for joining us here at TCF Live. I'd like to call your attention to the pinned chat tonight, the premiere live episode of In the Blind with Mike and Dan. There is a link in that pinned chat, takes you right to the episode. So head over there and hit the notify me button to make sure that you're notified when we go live. Mike and I are excited about this. Of course, we filmed the pilot about a week and a half ago, and that was fun. But we're truly working without a net starting tonight. We will be live. That's 7 p.m. Eastern, 4 p.m. Pacific, so please join us. Let's go to Florida. Wade Mercer.
Anyone? No? Okay. Well, if you tell me what case you're here on, I'll try to call it. I'll call it next, then, okay? Sure. All right, Mr. Booker, good morning. You're here for first appearance, accused of 3 charges. You're accused of 1 count of resisting an officer with violence, 1 count of possession of cocaine, and 1 count of possession of more than 20 grams of marijuana. Mr. Booker, I read the complaint. There is probable cause for at least 2 of the charges. I had some questions about the marijuana case based upon the type of test done, and so I sent a text to the state in defense this morning about that. Let's see what their position is on that, as well as bond issues. Mr. McDaniel, anything?
Just what you said, Your Honor, nothing else.
Mr. Mitchell?
Your Honor, we probably will get in contact with law enforcement on that, but we just, if you want to go ahead and set a bond analysis, we could set an ROR on the marijuana charge. But as for the other two charges, since you're finding PC, we just request he be subject to random UAs.
Since his allegations are over 20 and because of his history, I wouldn't do an ROR. I would either hold him unless Mr. McDaniel wants to stipulate for first appearance purposes just to get a bond set. Okay.
Okay.
All right. So Mr. McDaniel stipulating for first appearance purposes to a probable cause. And here's why, Mr. Booker. He doesn't want me to hold you 24 hours without you having a bond, which is one of the options. That's what I would do normally because your history, because it's of over 20 grounds charge. But to get you a bond set today, Mr. McDaniel is stipulating today only just to get you a bond set. He's not waiving any rights of yours. So giving that fact, you've got the 3 felony charges. They're all third-degree felonies. Your bond's going to be $5,000 each. Mr. Booker, your total bond is $15,000 cash or surety. Cash or surety, Mr. Booker, means you can go through a bondsman. You do not have to come up with all the money. You do have a condition of random urinalysis. That's a condition we put on every case. It's a drug-related offense or charge. So what that means is you can be drug tested at any time. Be aware of that. If you have something in your system that you don't have a valid prescription for, that could violate your bond. So, Mr. Booker, your bond is $15,000 cash or surety, and you will get a chance to use the phone in just a few minutes, sir, to try to post a bond. If you post a bond, you'll be released immediately. If you don't post a bond, the public defender's office will be in contact with you. Do you have any questions, sir?
No, sir.
Have a good day, sir.
Judge, what will be the court date?
Thank you. March 3rd. Thank you for reminding me, Corporal. March 3rd at 8:30. Kendrell Brown, and is it parents that are here? Parents? Mom? Is this mom? Mr. Brown, good morning. Mr. Brown, your mother's in the courtroom. Mr. Brown, you're here because you're accused of 1 count of violating the terms of your state probation. There is a no bond warrant that's already been signed by the circuit judge. So all I'm going to do this morning is I'm going to arraign you. What that means is I'm going to get you a lawyer appointed if you're asking for one, so we can get your lawyer on board. Mr. Brown, would you like to have an attorney appointed to represent you?
Yeah.
I'm going to appoint the public defender's office of the 14th Circuit to represent you. Listen to Mr. McDaniel. He's going to tell you when the court date is, and then we're going to see if you have any questions in just a moment. Mr. McDaniel.
No, we're going to plead not guilty, said on the March 5th court docket, and advise even the attorney from the public defender's office if it's in prior to that date.
So March 5th will be your court date. Mr. Mitchell, anything?
No, Your Honor.
Mr. Brown, an attorney with the public defender's office, probably Mr. Green, or could be Mr. Sims or Mr. Blunt. One of those attorneys will come see you at the jail before the court date. Do you have any questions, sir?
No.
Have a good day, sir. In the courtroom, do you have any questions, ma'am? Have any questions?
We're aware of his mental conditions, Your Honor.
So the only allegation is that he failed to attend treatment sessions from life management. That's the only thing he's accused of doing. So Mr. Guy Green will be his attorney most likely.
We're using multiple attorneys, so I don't want to say who.
Well, that's who was doing them until recently. Now it's kind of split up between a couple of different attorneys. But the public defender's office behind us, you may want to check with them and see who's going to be going to see him and make sure they're aware of everything. You think you're already aware of it, though?
They should be. I'm aware of it, so I would think that they would be aware of it. But it wouldn't hurt to let them know.
So you may want to contact the public defender's office, ma'am, and find out who's going to be his attorney. Okay. Thank you. Yes, ma'am.
I have no doubt Judge Garcia is aware of it.
We have Zachary Doolittle next. Mr. Doolittle, good morning. Mr. Doolittle, you're here because you've been accused of possession of more than 20 grams of marijuana. Mr. Doolittle, there is probable cause in the complaint. I'm going to appoint the public defender's office for first appearance purposes to represent you. I'm going to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, we just asked the court to consider conditional release. I think he lives in the area. He works here. I don't want to say what he does for a living, but he works here. We just asked for conditional release.
The only hesitancy I have about the conditional release is he has no history according to what I've got, but it's allegedly 56 grams. of marijuana, which
Double
is,
what a misdemeanor would be amount, or I guess triple what a misdemeanor amount would be, but it's still on not a, in the old days it may have been a lot, but most states that's personal use, but not in Florida. I'm not saying it is in Florida.
56 grams is personal use in a lot of states?
Yeah.
Really?
Yeah.
Mr. Mitchell, what's the state's position?
I mean, this is Florida, not Las Vegas,
I'm
but
not saying it is. I'm just saying he's got no history and he's telling me he's got a medical card for it. I'm not suggesting at all that what he admitted to is legal under a medical card at all.
I think the only, regardless of whatever it is, we just request he be subject to random UAs.
What is the state's position on bond versus release, Mr. Mitchell?
We would request a bond, but it doesn't have to be a felony bond.
Fair enough. Mr. Doolittle, there's two concerns that I have about a conditional release. You have no history, which is great. The amount of marijuana is one concern, and then there's an allegation regarding you allegedly attempting to stop people with flashing blue lights on your bumper. Now, you're not charged with that. That's in the probable cause affidavit that you were allegedly doing that. So I'm not sure why they didn't charge you. Maybe they thought they had enough evidence to do so. What I'm going to do is I'm not going to give you a conditional release because of the amount of marijuana and the blue light allegation. What I am going to do is just set you a misdemeanor bond. This is not a misdemeanor you're accused of, but I'm setting you the equivalent of a misdemeanor bond, which is $2,500 cash or surety. That means you can go through a bondsman. If you go through a bondsman, what they charge you is something you negotiate with them. Usually it's around 10% of the bond. 10% would be $250 if they charge you 10% to get out. Mr. Doolittle, you also will have a condition of random urinalysis, which means you can be drug tested at any time upon a court's request. So be aware of that possibility. If you take a drug test and if you got a medical marijuana card, having THC in your system may be okay, depending upon the amount, the concentration, and so forth. It gets complicated. Mr. Doolittle, you will also be given a notice for your court date, which will be March the 3rd at 8:30, and you'll get a chance to use the phone in just a few minutes, sir. Do you have any questions?
Yes, sir.
Have a good day, sir.
Sounds good.
Let me see, Donald Middleton. Mr. Pendleton, good morning. Your situation is the same as that of Kendrell Brown, who I saw earlier. You're accused of violating the terms of your probation. The circuit judge has signed a no bond warrant. Mr. Pendleton, that means I'm going to go ahead and get you arraigned this morning. If you want an attorney appointed, we're going to go ahead and get that done today and get your case moving. Mr. Pendleton, would you like to have an attorney appointed to represent you?
Yes, sir. That'll give me a chance to talk to Stephanie and everything, correct?
Well, that'll be the first step. It'll get the ball moving. That's right. So I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel. He's going to tell you the court date, and then we're going to see if you have any questions in just a second. Mr. McDaniel.
Your Honor, plead not guilty. Court date will be March 5th, and I advise an attorney to come represent him, talk to him about this case.
Thank you. Mr. Mitchell, anything?
No, Your Honor.
So March 5th, an attorney with the public defender's office will come and see you, and that's who you want to talk to about talking to. We say Stephanie. I'm assuming you're talking about Ms. Colbert, the placement specialist.
Correct. To go across the road.
Yep. Okay. So they would talk to your attorney about that, and they'll contact Miss Corbett, and she may already know about it. She watches First Appearance a lot of days, so she's very proactive. She may come see you at the jail and talk to you about it before then. Okay.
Yes, sir.
Have a good day.
Yes, sir.
Levi Gilly. I need to see Mr. Gilly.
Yeah. His sister does not live there.
Mr. Gilly, good morning. Mr. Gilly, you're here for First Appearance. You were seen this weekend. Good morning. You were set a bond of $1,000. You're being seen today because this is a misdemeanor offense. It appears you have no prior criminal history. I'm appointing the public defender's office to represent you for first appearance purposes. Please listen to your attorney, Mr. McDaniel.
Your Honor, Mr. Gilly is going to accept the PTI for 6 months, pay a $370 fine, $95 in restitution. His sister does not live at the house there with his parents, and I guess he kind of lives outside. I've talked to him about it. He's going to find a job, find something to do, live in a tent outside or whatever. He's going to have to do something.
So, Mr. Gilly, we've got to make sure we're on the same page on where you're going to go, first of all. So I can't let you have contact with the alleged victim, Miss Gilly, your sister, unless she wants it. So she does not live there, correct?
No, sir. She lives, no, she don't live there.
Okay. And you live on that property. Is that the same property your parents live on?
Yes, sir.
But you live outside in a tent or another structure. Is that right?
I live in the house outside. I don't live in no tent.
Oh, there's another house out back then that you live in, right?
Yes, sir.
And just to make clear, your sister doesn't live in that home or the other home where the parents live. She's not at that address at all.
No, sir, she is not.
Okay. And the PTI program that Mr. McDaniel went over with you, is that what you want to do?
Yes, sir.
Mr. Mitchell, is that agreeable with the state?
Your Honor, I've discovered this while we were looking this up. Mr. Gilly does have a review case that's out there for 2 counts of domestic battery against the same victim in this case and another victim. And I just sent an email to our victim advocate to get in contact with them, see if they're okay with just going forward on the PTI on this case, but the state would be requesting a little bit more time to see if we can sort of lump them together.
So there's a couple things we can do. We can just do a conditional release today and come back to court and deal with it later. The other option is go ahead and do the PTI with the understanding that the state may be asking for additional conditions to be added if that's appropriate from the state's perspective. Either way, it's your call. So what would you prefer to do, Mr. Mitchell?
The second option is pretty good.
So Mr. Gilly, you need to understand that we're going to go through this PTI if this is what you want to do. But
yes, sir.
You have 2 cases of battery that are in the state attorney's office they've not made a decision on yet. So they may come to you next week and say, we want to add a condition, no contact with blank, somebody other than your sister, because the no contact with your sister is going to be in there already. But then you have an additional condition of no contact with somebody. Now, you may say, no, I don't agree to that, in which case they will charge you with that battery. Or you may say, that's fine, I'll stay away from that person too.
Madison.
I will.
Andrews. You know Madison?
Some person named Madison?
That was my girlfriend.
Was your girlfriend? So I'm assuming you're not together anymore?
I guess not now.
Okay. I don't know. I just know that there's a battery complaint involving her. So I'm not putting a condition, no contact right now on her. I'm just telling you, if that happens, that may be the person that doesn't want contact. I don't want to speak for her, but right now that condition doesn't apply. But if that happens, that may be coming in the future. Okay.
Okay. Yes, sir. I understand.
So I don't, she may be fine now with a contact. I have no idea. And you haven't been arrested or charged with that. The state attorney's office is just reviewing a complaint. Okay.
Yes, sir.
Okay, so as far as the PTI in this case, this is what you want to do, right?
Yes, sir. But does that mean I will get out today?
Yes, sir. I'm going to show you a case referred to the PTI program for 6 months. Condition, no contact the alleged victim, your sister, standard court costs and fines of $370. And what were the other conditions, Mr. McDaniel? Mr. Mitchell?
Miss Williams and I were discussing a retail theft, but this isn't a retail theft.
It's not a retail theft.
No,
$95 in restitution, which brings up another question. You're the expert on this, the arrest. There is an exception to a warrantless arrest for retail theft. I don't know there's an exception to warrantless arrest for petty theft. Mr. McDaniel?
This clearly could have been charged as a felony, Your Honor. I mean, this is not even this is something different, doing fraud by, internet use and things like that. I think I don't see no issue.
You don't have any problem because they elected to charge him with a misdemeanor when they could have charged him with a felony.
Absolutely.
I just want the officer to be aware that from the misdemeanor perspective, this is not a case he or she can make a warrantless arrest in, Mr. Mitchell.
So based on my understanding.
Yeah, I don't think he can. It's not a retail theft, and it didn't occur in his presence. So would you please talk with the officer? And if I'm wrong, please let me know that. I don't think they can make an arrest in this situation, but Mr. McDaniel's not complaining because it appears they could have charged him with something more serious.
Correct. And because they could have charged him with that, I think arrest is not going to get a complaint by me.
Thank you.
And Mr. Gilly, I just going to advise you, stay away from Madison for at least for a while. I don't know what's going on with that. Obviously, no contact with your sister, but it'll help your cause out a lot if you stay away from Madison also. Don't talk to her, don't call her. Just don't stay away from her.
Mr. Gilly, what's going to happen next? They're going to let you use the phone in case you need to set up transportation and call whoever you wish, except the no contact people. With no contact person. You've heard Mr. McDaniel's suggestion. So you'll get to use the phone. After you use the phone, they're going to let you get dressed in your regular clothes. They're going to bring you to the courthouse because that's where the conditional release office is at. That's where the PTI office is at. When you get to the courthouse, you'll meet with Mr. Goodson or Mr. Ham, one of the conditional release PTI officers, and they'll go over the PTI with you. They'll make sure you don't have any questions that are unanswered, and then you'll be free to leave.
Thank you.
Mr. Gilly, If you call friends or family, tell them you can be picked up at the courthouse in about 30 to 45 minutes. Do you have any questions?
No, sir. Everything sounds good.
Have a good
Mr.
day,
Gilly,
sir.
let me remind you, if your sister Mr. Gilly, if your sister comes to your parents' house, you've got a place out back. You don't need to be around her, okay? That means you need to be away from her. If she comes
Yes,
over,
sir.
you need to go the other way. You understand?
Yes, sir, I will. Yes, sir.
All right.
Thank you.
Thank you. Sandor Kirkland. Mr. Kirkland, good morning. Mr. Kirkland, you were first appeared this weekend for a charge of aggravated battery, and the judge held you with no bond. Mr. Kirkland, what we do in a lot of these outer counties, these rural counties, is we put a time limit on that no bond hold. The reason we do that is we want the probation office to go ahead and decide what they're going to do instead of you just sitting there for weeks and weeks with no bond. So we put a 7-day time limit on it. So the only reason you're being brought back today is to put that 7-day time limit on the VOP. That 7-day time limit starts today. It's always the first working day after the arrest.
Yes, sir.
So I'm going to ask Mr. Mitchell to notify the probation office of the arrest. They have 7 days to get a warrant if they want to seek one. And Mr. Kirkland, if they get a warrant, you'll come back to first appearance within 7 days. And that I'll tell you if that judge that signed the warrant put a bond on it or not. Mr. Kirkland, if there's no warrant in 7 days, you'll come back to first appearance next week, which will be next Monday. And if there's no warrant at that time, I'm going to release that no bond hold and you'll be free to post bond on the new charge. That's pretty rare, but it's possible. Mr. Kirkland, do you have any questions?
No, sir, I don't.
Have a good day, sir.
Yes, sir. I don't. Look into that.
Corporal, I think that's it for first appearance purposes. Anything from the jail I may have missed?
No, sir.
And of course, he ends his day just as I'm finishing chewing. Apologies if I sound like I have food in my mouth, is because I do just a little bit. There is no better breakfast than cold leftover egg rolls. I'm just saying. Okie dokie. We don't get to go here often, but it's usually a joy when we do. Georgia, Judge Alex Manning.
Yes, Your Honor.
I think all the conditions have been removed, right? Just to have it?
Yeah.
Any idea when you think they'll indict it there, Mr. Jenkins?
I can inquire and I'll be sending an email today with our case intake division. But at this time, I don't have a date.
Okay. Let's see. He argues almost as much as you do, Mr. Shoemaker, Mr. Showalter. All right, let's see. And pre-trial, there's no criminal history. It's number 17. When's the next calendar, Miss? Is it already? Yeah. Is it already set, that calendar? No, I haven't. All right. How about this? If they haven't indicted it by our next calendar, we'll remove it. Is that good?
All right.
That
Yes,
gives them
sir.
plenty of time to indict it. If they don't, then that's enough. Okay. Okay. So we'll get you on the next one.
Sounds good, Your Honor.
What? All right, let's see. Danja Israel. Donajai, maybe I pronounced it. Last name is Israel. Is this one of yours, Miss Feely?
Yes, sir.
Yisrael, Mr. Yisrael.
Position 1. Is your defense present? Your Honor, the state, subject to Proper notice, Your Honor, state would ask bench warrant bond forfeiture.
All right, Ms. Feely, anything?
I will contact his attorney.
Okay, and we'll obviously hold it to the end of the calendar.
Yes, Your Honor.
All right, so we got Aiden King.
Mr. King's in jail.
That's okay, in Fulton, right?
He is. He was arrested on January 10th and being held without bond on a new burglary case.
So what do you guys a second chance want to do? Did he get, obviously it's dead or got cut off of it? What do you want to do? I mean, because obviously we don't need to keep paying for it if he's sitting in the Fulton County Jail.
So we did unassign it, so we're not charging y'all for it, but if he was to get back released, then the jail would call us for us to put it back on.
All right, perfect. Thank you. Amari Coleman. I've got that he may be in the Clayton County.
Great, Granny. Thank you for the $2 chat dedicated to making Barb laugh. Yes, let's all make Barb laugh. I agree.
Really?
Okay. All right, so I've got, let's see, Anastasia, Alaya. Let's see, Anastasia. Looks like there's a. Come on up, ma'am. Is your lawyer here? No?
Like the public defender.
Oh, is this, all right.
Yeah, Mr. Pete is a public defender, Your Honor.
Oh, okay. All right, what do we got, second chance?
We just have one curfew violation on 124, made an unauthorized stop at a Starbucks before arriving at her work location. We have received several no motion alerts from the defendant, so we would like to check the device for looseness as we believe the defendant may be slipping.
It looks like you had, try it like May the 11th.
May the 11th. I don't have any notification of that as of yet.
Anything there, Miss Feely?
No, I'll reach out to Mr. Pete and see if he wants to file with Judge Ingram to have it removed.
All right, yeah, and I can also let Judge Ingram know. Anything there, pre-trial? All right, thank you, ma'am. Well, I'll reach out to Judge Ingram. All right, thank you, ma'am. Yeah, on here it says May the 11th at 9 a.m., but nothing may have been sent out yet. All right, let's see, Anquibian Sanders.
All right, Mr. Tevis. Counselor?
Well, how are you?
Right? I don't think he's.
Oh, we got second chance.
So we don't have any known violations at this time within the last 60 to 90 days, but we do need the victim information to enter the stay away.
The victim's information, you said?
There is no stay away. The person's deceased. I mean, for the victim.
What does it say, the victim's family? Or what does it say on
The
there?
bond order says no contact with the victim.
That's, I'm thinking maybe they said victim's family. I don't,
My notes indicate family or witnesses.
Oh, okay.
I don't have a copy of the order.
Any
Just
potential
for the
witnesses?
court's own notification, if the state were to move forward with this case, this is not an incident where it's like a felony murder charge. So it's a friend of his who was killed, not somebody that he shot or anything like that.
Looks like there's maybe a co-defendant on this. Maybe, well, looks like that's what was in the order. So yeah, there's really no one except you say the family, you can say the family of the victim. I don't know anybody's name in particular.
Need all the friendliness we can get. I'm gonna send this to Mike, see what the status is.
All right. All right. Thank you so much. I appreciate it. Have a good one.
Thanks, Judge. Is there a standing now on when we should ask this to be removed? We're almost at a year.
Any idea when this will be indicted, Mr. Jenkins?
Your Honor, I will check also with Deputy Mike Sprinkle in connection with charging status.
All right, same thing. Maybe if they don't have it indicted by, next, we'll put you on the next calendar. and we'll consider removing it.
Hey, Judge, the incident date was 2 years ago. It's just.
Yeah, it looks like he was arrested though in
February of last
February.
year, you're
Right.
February of 2025, yeah.
All right, my friend.
Judge,
Have a good one.
we know when the next calendar will be. The last one was in November.
Well, yeah, Ms. Shaba said that, let's see, probably like the first Monday in March.
No, I mean, we'll be back in March on this case. Oh, okay.
All right, what about Benjamin Stevens?
My lawyer is on a 9 o'clock calendar, that she'll be in here a little bit after that.
All right, anything pretrial? Second chance?
Yes, so the bond condition states that he must travel to work via Fairburn Industrial Boulevard to Oakley Industrial Boulevard and stay off Highway 92 and Spence Road north of I-85. The defendant has several exclusion zone violations for January and December because he's traveling through the exclusion zone of 92 and Spence Road, 13 days in December and 11 days in January.
All right, so how about we just wait on your lawyer to get here, okay? Let her address that. All right, thank you. Carl Mack. Carl Mack. Jenkins.
Yes, Your Honor. Subject to proper notice, Your Honor, state request bond forfeiture bench warrant.
All right. And once again, Ms. Beasley, I don't know if this is yours, but we'll wait to the end of the calendar. I've got Denaja Higgins.
Defender as well.
Let's see. Second chance.
Defendant just has one dead battery in the last 60 to 90 days, no other known violations.
Pretrial. I think, so,
Public defender, so it looks like
Yeah,
maybe
it
we.
is. yeah, and it looks like, second chance, y'all need an updated address, or has an updated address been filed for you? Have you moved?
No,
Looks like one hearing notice was returned. That was in,
I still live at the same house. The house where I live at is not the same house as on my ID though.
oh, no, I mean, but you got this notice.
Huh?
Did you get the notice of this hearing?
Mm-hmm. With
Oh,
the
okay.
address for where I live at on the paper.
Oh, that's what I'm saying. It looks like the other one in December was returned, so I was just making sure.
Oh, I don't know. I just got this one probably like last week. It came late. It came with a red clip and said like return or something.
Yeah, I'm not real sure about that. All right,
Yeah, therefore, yeah.
let's see. Looks like you had it on since what? April?
I will respond.
All right, thank you, ma'am. We appreciate it. Thank you.
That's it.
Yes, ma'am. Daniel Manleo. You can go, ma'am. Thank you. Have a good day.
Child. Okay.
Yeah, you're done, ma'am. Thank you. All right. Go ahead, second chance with number 9.
No known violations within the last 60 to 90 days.
All right, pretrial. Who's that? All right, let's see. All right, anything, counsel?
Yeah, good morning, Your Honor. My client's been on this ankle monitor for 11 months. No violations. There's been no movement on this case. It's still unindicted. So we'd ask to remove the ankle monitor.
What do you think, Mr. Jenkins?
Well, with the type of charges, Your Honor, these cases take some time, and so I will inquire of our case intake division and our crimes against children in connection with this matter, and inquire if you want to. We request that you continue this matter until March for status.
Sound good?
Okay, Your Honor.
All right, thank you, sir. Have a good one.
Thank you.
Hey, brother. That's
All right, I got Darian Stewart. Darian Stewart. right, second chance, what do you got?
He has 2 dead batteries within the last 60 to 90 days, but no other known violations.
Pre-trial. All right. Ms. Feely, you got anything?
No, Your Honor, he's substantially in compliance.
Oh, okay. All right. You had it on since January or February?
Yes, ma'am.
And it's still the same thing, I guess, Mr. Jenkins, he worded
Yes,
in
Your Honor.
indictment.
That's
Go
the
check.
standard request from the state today, Judge.
All right. So we'll see if we can't put you back on the March calendar, see if they've got it indicted.
Okay.
Okay, thank you, sir.
Thank you.
Was it, well, I mean, you know, was it dead because you forgot to charge it, or do you think something's wrong with it?
I work overnight, so sometimes I'm either, I kind of probably forget it. It's
Okay.
totally honest.
All right, sounds good. Thank you, sir.
So I don't know what this says about me, but this is a compliance calendar with Judge Manning. So they're bringing people in to see how they're doing on their probation, all that. And I get that. But every time I hear dead battery this morning, my brain is interpreting that as battery on a dead person. So like taking a corpse and beating it up or something. I've got no idea why, but that's just how it's hitting my brain. Maybe because I'm just a weirdo. I have no clue. Let's change it up slightly. And by slightly, I mean a lot. Let's travel up to Michigan, see what's going on with Judge DeSanto.
We're here on behalf of Marion Mackey. State your name for the record, sir. Marion Mackey.
All right, good morning. Thank you for dressing appropriately for court. And today is the date scheduled for the arraignment pretrial in these matters in council.
Yes, Your Honor. My client waives formal reading and stands to the charges.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And as to the pretrial counsel.
Yes, Your Honor. My client is prepared to offer a plea of guilty to the amended charge of operating while visibly impaired. The original operating while intoxicated would be dismissed. Also, there'd be a responsible plea to the civil infraction of the refusal of a breath beverage.
All right, and so, sir, I'm going to have you please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, don't worry. Everybody tries to put their left hand up first because it's directly across from my right hand. And so, sir, you did you pick him up, Alan?
Yeah.
Okay. You heard the plea that was placed on the record, correct?
Correct.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
As to the charge of refused PBT, how do you plead? And you've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights.
Correct.
You also understand by entering into a plea that you'll be waiving some of those rights.
Correct.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Correct.
Knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
And, counsel, if you can please voir dire your client.
Yes, well, Mr. Mack, you recall being in the city of Riverview around the 28th of December last year?
Yes.
And at that time, we were operating a motor vehicle?
Yes.
And prior to operating that motor vehicle, had you consumed some alcohol?
Yes.
And how much and what, if you can recall?
I don't recall what, but 4 to 5 drinks, I'd say.
Okay, and you were drinking at a local bar in the city of Wyandotte?
Yes.
Correct? And then after having consumed that alcohol, you managed to crash that car into some parked cars. Is that correct?
Correct.
You believe that your consumption of that alcohol impaired your ability to operate your car?
Yes.
Your Honor, I'm satisfied with that.
In what way did it impair you to operate your vehicle?
Like what effect did it have?
Yes.
Your Honor, if I may.
Yes.
Do you normally, when you're driving your car, you normally crash into other cars, whether it's others like?
No.
Okay, so that's unusual for you.
Yes.
And so do you think that if you hadn't been drinking, you wouldn't have hit those cars? You wouldn't have lost control of your vehicle?
No.
And also I need to touch on there was a blood draw after you were arrested. You recall cooperating with that?
Yes.
And the medical report indicates that your blood alcohol level was at a 0.157. Do you dispute that?
No.
Okay, very good. Thank you. The court is satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge as well as to the refused PBT and dismiss the original count 1 per the plea agreement and counsel as to bond.
Yeah, as to bond, Mr. Mackey is, he's a young man. This is out of character for him. He's got no prior run-ins with the law. He is in a training program to be an insurance agent. And at this point, he never had an opportunity to fail to appear. So he's never, as I said, he's never failed to appear because he's never been ordered to appear. So again, based on that, he understands and he's going to, he's obligations to this court. He'll comply with whatever the court requires. We ask for a personal bond in this matter.
All right. And so, Mr. Mackey, so it shows as though you had an address in East Lansing. Are you in East Lansing or are you in Wyandotte?
I'm in East Lansing.
Okay. And so are you at school? Do you attend school?
No.
Out there? No, you just have relocated there. Okay. So.
And I advise Your Honor if he get his license updated if he hasn't already done so.
All right. Let me just clarify. It shows Lansing, not East Lansing. Okay.
Lansing, correct.
Lansing. All right. Let's change this. It's 155, correct?
Yes.
All right. And so you're in classes, you're studying for to be an insurance agent, life insurance agent?
Life insurance agent.
Okay. And you're not currently on probation or parole anywhere since you haven't had any run-ins with the law before, correct?
Right.
And you're not out on bond in any other jurisdiction?
No.
You're to test right now, sir. Is there anything in your system that you're not prescribed?
No.
Okay. The court's going to order a $5,000 personal bond. You are not to possess or consume any alcohol or drugs that are not prescribed.
Okay.
And so you get a copy of your bond conditions. That's interesting. And then you're going to go over to probation. You're going to receive a copy of your bond conditions. You're going to receive your link for your needs assessment. You're going to also receive, sir, your next steps and your dates to come back. Okay?
Okay.
All right. Have a good day.
Thank you.
Yeah. Okay.
It's TCF Live. It's Monday, but this is the place to be on Mondays. It's what turns that Monday frown upside down. Go to Texas, Judge Stevens.
I'm with the probation office. Have it. Thanks. So 24 CR 1619 is now called the State of Texas versus Dustin Coy Keffer. Is that you?
Yes, sir. Yes.
Present with Mr. Adams, your attorney, and the state's attorney. There is a motion to revoke probation that was filed on October 21st of last year. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
And Mr. Keffer, raise your right hand, sir. Do you solemnly swear or affirm any witness that you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your feet. In summary, sir, this motion states that on August 11th, 2025, in this court, you were sentenced to 10 years in prison, and that was probated for 10 years for the third-degree felony of fraudulent use or possession of identifying information or items. Do you understand what you're charged with?
Yes.
There were more than 5, less than 10. That's a third-degree felony, which carries with it up to 10 years in prison. Number 1, violation states you failed to report to the Jefferson County Probation Office on or about August 12th. That would have been the next day after you were placed on probation, and for the months of August and September 2025. Is that true or untrue?
Yes, sir.
When were you arrested? I guess. In 21. Yeah, when you didn't show up for September, then motion to revoke probation was filed in October.
PRP in December.
In December?
And
he was in custody whenever he took this deal, and then he didn't show up after that, General.
You're right. Hold on. I've lost the thought on that. So did you ever report?
Yes, sir, yes. I got you. Yes, sir. Got out, was down and out. And had a lost my job while I was incarcerated. Just made a mistake. Mission to fix it.
And just up to my understanding.
So,
and he's going to accept responsibility for everything.
Allegation 1, then, failing to report August 12th, 2025, and August and September of 2025 was a violation of condition 4 of your probation order, requiring you to report regularly. Is that allegation true or untrue?
Here.
And then number 2, you failed to provide verification of performing community service hours as required. I presume you didn't serve any of that, correct? Is that true?
Yes.
Are you pleading true to allegations 1 and 2 voluntarily, and because those allegations are indeed true as they are alleged?
Yes, sir.
You understand that a voluntary and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation. Your probation can be revoked. You can be sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes, sir.
Knowing, understanding, and appreciating that, do you insist on pleading true to allegations 1 and 2 of this motion to revoke probation?
Yes, sir.
I find you are pleading true to allegations 1 and 2 voluntarily, knowingly, intelligently.
Not to interrupt, but I have to interrupt. I got to step out of the studio for a few minutes, so we're going to run with Judge Stevens and hope that if I'm not back before the end of this hearing, he's got something else immediately, but hang tight.
So this was the crime of fraudulent use of
identifying information. There were some items in the bag that was discovered.
They arrested you in this case. Let's see, you were in possession of a Texas DPS issued driver's license. I don't know if that was yours or not. A Texas DPS issued ID card. I don't know if that's yours or not. 2 passports, a Discover card, credit card, and a personal check with the identifying information of other people thereon. Six pieces of identifying information were located amongst a backpack full of mail that did not belong to you. And so you were charged with fraudulent use or possession of identifying information. I'm looking at your criminal history. You were in 2009, you were placed on probation for credit card or debit card abuse. What a similar event. And you were placed on probation and you didn't make it a year. You were revoked and sentenced to 10 months in the state jail, correct?
Yes, sir.
And then in December 2010, you were sentenced to 8 months in the state jail for committing forgery of a financial instrument in July of that year. After you had committed the credit card or debit card abuse crime, and after you were placed on probation in that first case, then you committed forgery. And let's see. in this present case, fraudulent use or possession of identifying information, which has been your crime of choice, apparently, is deceit and abuse of forgery, theft, misuse of other people's identification. You know how you know how much problem of a problem that becomes for the poor people who have their identification misused. It gets into the system and then it's a blemish and they have to deal with it a lot of times their whole life because it pops up and they're questioned about, well, it's showing up that your identification was misused. They're the ones that have to pay the price. They're the ones that lose their credit rating. They're the ones that lose opportunities if they want to get a loan or get other credit cards. I mean, it's a mess forever for these victims. But this is your crime of choice. This was the third time you were dealt with, and we ironically gave you a third chance. And didn't take you long before you misused it. Immediately. All right. Give it your best shot.
Judge, the state had made us an offer for 5 years. My client declined that, and he wanted to go to you. And the biggest thing when we talked was his acceptance of responsibility. And he has accepted responsibility. Well, he has. He's admitting true. I mean, he's not denying the allegations.
So wait, what things? Okay, that's great. What we don't want him to do is keep committing the same type of crime.
Right. And
how many times do you have to get punished?
Right.
It's like you keep touching the hot stove.
Right. And
now you're not touching anymore. You're embracing the stove now.
Right. But I guess the reason why he's touching the stove, Judge, is your analogy is absolutely on point. We would think it's irrational to touch a hot stove, right? That's irrational. So now we got to get into how do we explain irrational behavior? And the way I'm explaining his irrational behavior is my client has suffered with dependency for most part of his adult life, particularly the drug.
Dependency of what?
That's what I'm saying. The particular drug that he had been dependent upon was methamphetamine. And Judge, as we all know, that meth can cause us to make irrational decisions. And
wait, hold on. The first irrational decision is using it in the first place. Well, he wasn't on meth when he used it in the first place. He made a conscious choice.
Well, that's true.
And you don't get hooked immediately.
That's true.
But you kept making the wrong choice, just like you keep doing this. Come on.
Right. And
we all know it's wrong. We all know what can happen to you if you misuse it. It can become addictive. Everybody knows that. It's not like that's news to anyone.
Right.
But you make a choice. You've made choices that are consistently the wrong choices. And here's the problem. It hurts other people, not just you. Well, bad enough it hurts you, but you got all these other people victimized and they have to deal with the blemish on their credit and questions of their credit worthiness because of you. It's you poison the well.
And just what I was saying is because of that meth dependency and addiction, it causes him to have had some financial issues. And like he just told you before, he didn't have transportation. He really didn't have any money. So that affected his ability to report and do the community service. And what the saying, Judge, is this. Instead of locking him up and putting him in prison, what he's asking is for the court to let him get some help. And what I would think might work for him is like safety. And because ultimately, like you just said, touching the hot stove, right? Why is he touching the hot stove? The answer is the methamphetamine use, the lack of funds. I don't believe he has family support.
How long have you been how long have you been appreciating that you were dependent on drugs?
Yeah.
Well, a better part of 2 years.
What stopped you from going and getting help? 10 years. Well, how's that been working? You keep getting arrested and you still make it Didn't understand it. It wasn't all that hard. What about
So Judge's audio just went really, really weird. We'll stick with it for a minute, see if it corrects. Otherwise, we need to move on.
We're making a difference. Another opportunity. It's very humbling. They have got one out. On that out. You got a hand in your eyes out of one machine. This one shouldn't be. Maybe fourth, no fifth, right? Maybe fourth or fifth. Well, when you report it before you sign it off, and the IP to follow up and give those something
We're a couple minutes in the Wayback Machine. I'm going to try to push this forward and see if it corrects.
If you had a choice each day, what you requested on December 2nd. And so apparently since December 2nd, to come up with this program, because it's try to convince you that the last connected to the choose to sell. So I'm sorry that they have to change. So wait 5 years, it's fair.
In your final plea to the court for mercy and your final plea to the court to allow you to continue to be on probation, the judge is giving you that opportunity to speak last. So go ahead.
Yes, sir. Again, I'm sorry. I apologize. This hasn't been a plan that was just made up today. Again, I know I've done wrong. I am accountable for those. Again, I just want to do what's right and be there for my child and make a difference. I'll pay, I'll show up, whatever needs to be done. I just didn't have, last time it was getting out, I lost everything. And it was a whole.
No, you didn't. You had a child.
My child.
You had a child. What do you mean you lost everything?
As far
you
as
had a child to live for.
I do have a child that I love very, very.
To set an example for.
And this is not the way to do it.
Since she's been born, you've committed how many crimes? One, two, three, four. Okay. If nothing further, I'm going to find Mr. 1 and 2 in this motion to revoke probation voluntarily, knowingly, intelligently. There's sufficient, that is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. And it is granted, and your probation is hereby revoked. Earlier, you pleaded guilty in this case, voluntarily, knowingly, intelligently to the underlying offense of fraudulent use or possession of identifying information or items. And there was enough evidence supporting your guilty plea from State's Exhibit 1 admitted at that time to find you guilty beyond a reasonable doubt. I found you guilty, sentenced you to 10 years in prison, but suspended and placed you on probation. You have failed on probation by the violation of these terms in probation, and you immediately upon probation failed.
I apologize.
Your probation is revoked. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case, which it looks like 121 days you will be credited with. Mr. Ham. That is it.
Thank you for your assistance.
Ever, Mr. Burbank.
All right, he definitely has some audio issues, stuff going in and out. We'll keep an eye, though. Let's change it up. Let's go to Louisiana, to the parole board, where if you look behind the contestant, it looks like Mrs. TCF's Walker is making a guest appearance.
Morning. Our next case will be that of Mr. Buffington. Good morning, Mr. Buffington.
Can you speak again? He's kind of hard of hearing. We got it.
Yeah. Good morning, Mr. Buffington. Would you introduce yourself to us? Tell us your name and your mailing address.
Name and your mailing address.
I'm having a little trouble on the sound. Can you hear me okay there?
Yes, sir, we can.
Okay.
They want your name and your mailing address.
My name is Guy Jefferson Buffington Sr. And my mailing address is 103 Port 71106.
Thank you, sir. And we see that you have your son, Guy Buffington Jr. with you today. And Mr. Guy Jr., thank you for helping us communicate with your dad. I understand he's hard of hearing, so we appreciate you facilitating it. Mr. Buffington's case this morning has been, well, first, let me just read some identifying information into the record. Mr. Buffington is here today seeking a pardon with restoration of firearms. He was sentenced in Morehouse Parish in July 1956 for a simple burglary conviction, and he received a 2-year sentence. Is that information correct, sir?
Yes, ma'am.
Thank you, sir. Your case has been assigned to Mr. Tillis, who is seated to my far left. Would you answer his question?
Good morning, Mr. Buffington. How are you?
Sorry.
I read through your case and I just have one question. Have you been doing any more stealing?
Have I been doing any what, sir?
Stealing lately?
Any more stealing lately? Have you been doing any more stealing lately?
Oh, no. Oh, no.
Okay. Why do you need a firearm?
Why do you need a firearm?
Why do I need a firearm? Well, I think if you look at the activity and violence and stuff that's everywhere around us, you almost require one. I have one, but it's put up in a safe place. I don't carry it with me. It's primarily for home safety.
Thank you so much. I have no more questions.
Mr. Guy Jr., what would you like us to know about your dad?
Well, not knowing what to expect, if you'll bear with me, I prepared a statement. It's short, but okay. I submitted a letter with the application.
Yes.
And I'm sure y'all have seen that, and I stand by all that was submitted there.
but I wanted to give you a little bit more information today if I could. And that I've known about this part of my father's life since I was in high school. My parents were concerned because I was growing a chip on my shoulder. I was anxious about my future, what career path might be open to me. Popularity I didn't have, money we didn't have, and looking towards my future, where would I be 5 or 10 or 15 years down the road? As a boy of 16, I learned that the man that I looked up to spent 4 months in state prison and 20 months on parole or on probation for stealing a Coke and $2 or $3 worth of nickels. After he ran a paper route one Sunday morning, they decided to tell me, my parents decided to tell me about it at that time because I think they were concerned that I might have heard about it from a relative that was familiar with it, and they wanted to make sure I had his side of the story and that sort of thing. Well, 12 or 13 years ago, he came to me again, to me and my wife, and essentially wanted to confess to her about this black mark on his record, to make sure that she knew about it, and at the same time was telling my other siblings and their spouses about it. I think he didn't want us to be blindsided, or didn't want them to be blindsided if something came up. My brother Joe at the time was director of finance for Bossier City. He was dating a long-term friend that was active in politics. And maybe they were concerned about it might be fodder for a mudslinging campaign, although that hardly ever happens in Louisiana politics, but just in case. The point I'm trying to make today is that my father's been ashamed and embarrassed by this part of his life for almost 70 years. And he's done everything in his power to make it right by being a good man, a good Christian, a good husband, a good father, a good employee, a good grandfather, and a good citizen ever since he was released from Angola in November of 1956. But the Bible teaches us that you can't earn forgiveness. It's a gift that must be given or granted. In my opinion, one way to gauge a man's character, since his character is at question today, or part of this exercise, is by looking at their children and their children's children to see what principles were taught and reinforced. And I can tell you that the successes we have had, that we have enjoyed, came from hard work, honesty, respect for other people, honoring God, helping others, all which came from his example and my mother's example and their training and their leadership. In preparation for this, for some reason, I thought about The Scarlet Letter, a novel by Nathaniel Hawthorne that I read in high school. Sure, most of you've read it, but let me summarize it briefly in that it's a story about a young woman who had an affair and bore a child. She was married at the time, and so was her partner in crime, so to speak. She refused to identify her partner in the affair, but as her punishment, she was forced to wear a scarlet A on her clothing to let everyone know that she was an adulterer. Much later in the book, we found out that he was a prominent person in the community. She took all the blame. She carried all the embarrassment and ridicule and spent the rest of her life seeking redemption. Her legacy was a daughter that was raised to be a respectful and respected part of the community. So there's some commonality between that story and my father's life. He took the blame for his mistake. he carried the embarrassment and raised his family to be respectful and respected contributors in their communities. He appears before you today seeking redemption and forgiveness, and I hope that you grant him that request. One more point. My mother passed away June 13th of 2023. He misses her dearly, and he hopes, prays, and expects to be reunited with her sooner rather than later. On her behalf, I ask that you grant this request so she can see him for the first time without his scarlet letter. So I appreciate your attention and your patience.
Yes, sir. And thank you for those words. Are there any questions? Let me just, for the record, let you know, both of you, we do, as part of the process, seek opinions about the application. And so we reach out to the local community. The sentencing judge or the sitting judge is unopposed. The district attorney is unopposed. We didn't receive any comment from the sheriff. That's a good thing. The chief of police expressed some opposition. Of course, the family, your family, is unopposed, and the attorney general's office had no comment, which is also a good thing. So those are things in Mr. Buffington's favor. I think we're ready to vote. Mr.
Yes.
Tillis?
My vote is to grant with firearms.
Mrs. Stapleton?
I vote the same, and I think that what you did in punishment was very harsh and excessive at that time. So if you're looking for forgiveness, you have mine already, and I think you had the Lord's a long time ago.
Mr. Prater?
Grant.
And mine also is to make the recommendation for a pardon with restoration of firearms. So you got the vote you need, Mr. Buffington. We're going to make that recommendation to the governor on your behalf. Good luck to you, sir.
Thank you very much.
So that was bizarre. Kind of hard to follow. So the board recognizes that he was punished harshly in the past. I joked in the chat that a Coke and a handful of nickels, when you translate that into to today's dollars, is probably grand theft. But then you're speculating in the chat that he wants the pew-pew to meet his maker sooner rather than later. Maybe. I don't know. Really bizarre. Anywho, let's Texas Judge West Fashion Show Monday.
Mr. Dickinson, did you get someone hired?
No, Your Honor.
Who'd you talk to?
I talked to James R. Martin, who quoted me $7,000. Reverend Jackson quoted me $7,500, and the Gertz Kelly Law firm that quoted me $6,000.
Okay, and so where are you on being able to get someone hired?
Your Honor, when I did apply for court-appointed lawyer, I had a higher paying job, but since my arrest, I got suspended from my job.
Okay.
Now I only make like $800 a month. I have a car and a apartment lease.
Okay, so thank you for doing what I asked you to do, Mr. Dickinson. I'm going to have you fill out some paperwork again this morning, and I'll take a look at it to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely, because you're going to swear under oath that it's all true, and I'll take a look at it then. If you'll step in front of the clerk, she'll give you that paperwork. Michael Garrett.
Michael Garrett.
No response, Your Honor. This bond will be forfeited for non-appearance and reset at $100,000. Aaron Riley. Good morning, you're Erin Riley.
Yes.
And Miss Riley, were you able to get a lawyer hired?
No, ma'am.
Who'd you talk to?
I spoke with Ms. Holly Holmes, and she quoted me like 5,000. And I spoke with, I can't remember the name of the guy.
Did you write it down?
No, ma'am.
Why not?
I wrote it down, but I left it at home.
Okay, so who else do you think you talked to?
I don't know what the other names are.
Okay. Don't you think that would be important to bring,
Yes,
since I
ma'am.
asked you to bring that and have their names?
Yes, ma'am.
Give me just a second to look at something. I'm printing something out. Stand up. Miss Riley, if I test you this morning, are you going to have something in your system?
No, ma'am.
Have a seat in the jury box. Let's check that first.
While she racks up the next contestant, let's head next door back to Judge Stevens.
We call 25 CR 947, the state of Texas versus Jeremy C. Bowman. I guess you're Charles.
Yes, sir.
Jeremy Charles.
Yes, sir.
You are here with your attorney and the state's attorney. Mr. Dusler, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment, what are we doing?
Counts 1 and 2 make it a state jail.
Because there's several paragraphs in this.
The misdemeanors make it enhance it to a state jail felony. Counts 1 and 2.
That's correct, Judge.
And then okay, what are paragraphs 3 and 4? Make it a third degree or second?
If it would be a third
Would be a-
degree, if the state.
Those are both state jails, so it'd be a third degree. We're just proceeding on state jail.
Yes, sir.
Is that right? Okay. In summary, this indictment in paragraph 1 alleges that on or about June 25th, 2025 in Jefferson County, Texas, you committed the state jail felony of evading arrest or detention with a previous conviction. And paragraph 2 goes on to allege that you have been convicted 3 times, at least, in 2004, 2010, and 2023 out of County Court of Law number 3 in 2 cases, and in this criminal district court of Jefferson County, Texas, in 1 case, that was evading arrest or detention with the use of a motor vehicle, wasn't it? On that one, that's different than these other.
Yes, sir.
Was he just running from the police?
Yes.
Yes, Judge.
Well, they keep catching you.
Sir.
They keep catching you.
Yes, sir.
Why do you keep running?
I'm done with it, sir.
Yeah, boy, I wish I had $1 every time I heard that, really. It's up to you to decide, really. So don't talk the talk, walk the walk on it.
Yes, sir.
Do it.
Yes, sir.
Paragraphs 1 and 2 constitute a state jail felony. Do you understand that? Because of the prior convictions alleged of evading arrest or detention in paragraph 2.
Yes, sir.
So anytime you run, it's at least a state jail felony.
Yes, sir.
It means you face at least 180 days in the state jail, up to 2 years in the state jail, and a fine up to $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be sentenced to 15 months in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do we erase on these pads?
You have to hold the button down on the pin and the whole button.
Oh, yeah. Down here. You can't make this stuff up. It's more convoluted than ever. It's how. Who'd have thought that's the way this would work? You know, yeah.
How should there be that coordination done?
I heard it. So, how do you plead to paragraphs 1 and 2, guilty or not guilty?
Guilty, sir.
You plead guilty voluntarily and because you are guilty.
Yes, sir.
And on paragraph 2, those 3 prior convictions of evading arrest or detention in 2004, 2010, and 2023 out of this criminal district court and county court at law number 3, respectively. Are those allegations all true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily?
Yes, sir.
I'll show you what's marked as State's Exhibit 1. If I can get to it. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection. It's in among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
If nothing further, I'm going to follow this and find that you are pleading guilty here in paragraphs 1 and 2 voluntarily,
Yes, sir.
knowingly, intelligently. That constitutes a state jail felony.
Yes, sir.
There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this state jail felony. I so find you guilty beyond a reasonable doubt. I am following this agreement. You were hereby sentenced to confinement in the state jail for a term of 15 months. You understand what has happened today, sir?
Yes, sir.
Anything else to
No,
add?
sir.
That is, yeah. You want to,
Like all my time that I've been sitting on account towards the state jail. What is it that you?
you will be given credit for all time you have served in conjunction with your sentence. And you're not the first person who asked that. I find it ironic. You are worried about the wrong thing. We take care of our business. What you don't do is take care of yours.
Yes, sir.
That's what you need to be taken care of.
Yes, sir.
But we never have problems with it. You always get the credit. We're going to do our job
Yes, sir.
properly. You just need to start following the rules and following the law and quit coming up here and worrying about everybody else's business. You need to take care of you.
Yes, sir.
Okay. Anything else?
No, sir. No,
That's
sir.
all. Thank you.
All right.
Here. Now it's gone black. Hold on. Don't figure it here, so.
We could do a super cut of just Judge Stevens complaining about those pads that they use there in Jefferson County, and it'd probably be like a 30-minute super cut. Crazy. Reminder, pinned chat, In the Blind with Mike and Dan, premiere live episode tonight, 7 p.m. Eastern, 4 p.m. Pacific. Please do join us. There's a link to that episode right there in the pinned chat. So head over there, hit the notify me button, So you are with us when we go live tonight. That show's a lot of fun. Mike and I did the pilot episode about a week and a half ago, and that's available now. Long and the short of it, we've got no idea what the two of us are going to talk about until we start the show and it's presented to us. So a lot of fun. Find me two other talking heads out there on YouTube who do it quite that way. And that's what makes it unique. Anywho, while they rack up the next contestant there, let's go back to Judge DeSanto.
And we have Mr. Shelton, who appears to be assuming.
Thank you. And Mr. Shelton, if you can please unmute and state your name for the record, please.
Timothy Shelton.
Okay, good morning. And today is the date for the arraignment in this matter as your client is in custody. Counsel as to the arraignment.
Wait for reading the client's statement.
The court will waive the formal. You need to stay muted. 23rd District Court, you need to stay muted. The 23rd District Court cases, you need to stay muted. We'll waive the formal reading, enter plea of not guilty for purposes of the arraignment. Schedule this matter for pretrial on February 12th.
8:45.
8:45 a.m. Because I'm not addressing you right now, ma'am. You need to stay muted. Thank you. And counsel as to bond.
Your Honor, my client's not on probation or parole. He indicates that he does work with his brother out of the city of Detroit. I did tell him that he would not be able to return to the address while this case is pending because he does list that as his resident. He indicates he believes he can reside with his younger brother in Detroit as well and be able to provide an address. Your Honor, considering that there'll be a no contact provision, potential gainful employment and a strong family support system, I know financially he indicated that he doesn't have access to any funds at this time, so I'd ask consideration for a personal bond. Thank you, Judge.
Okay, and so Mr. Shelton, I know when I saw your name on the on the docket today, I was you've been here a few times before.
Yes, ma'am.
Yes, you were just here last year, about 6 months ago, correct?
Yes, ma'am.
And what happened with that case?
It was dismissed. I did my time.
I'm sorry?
It was dismissed. I did my time and they let me go.
Well, you did your time because you pled guilty, or it was dismissed because they were not proceeding forward?
I thought it was honestly, I thought it was dismissed because I did time. I don't really know.
Okay, just
I've
one.
been going since then, so I really don't know.
Okay, just a moment, sir. So I think it was from March of 25.
March of 25.
Yes, I think so. Yes, March 16th to 25, assault.
This is something from 20.
Okay, what about, okay, what happened with that one?
He pled guilty to disorderly. Oh, so it was from 2022, but it was handled in 2025, so that's what it was.
Okay,
He pleads guilty to disorderly, and then that 30 days jail, credit 30 days fine, costs, and he has to.
okay, all right. And so, sir, you pled guilty and you had credit for the time served that you were in custody. So, where do you work, sir?
Can you repeat that again?
Where do you work?
Well, I don't have a residence where I work, but my oldest brother is an entrepreneur on the come up. So I've been helping him when he called me to help him fix on houses in the city. That's all I've been doing.
So you are working, but not steadily.
Yes, ma'am.
Why aren't you working steadily, sir?
Well, since the last time I got arrested when I was in Lincoln Park, I don't have all my things, like far as to be able to get a regular job, because all my things was burnt up in 11798 West Side Drive. So I've been trying to make a little money here and there to get my social, my birth certificate, and be able to move forward in life. But all I got is the ID, so ain't no job gonna hire me with just a state ID.
That's not accurate, sir. As long as they can identify you as an individual, you can still be hired. People hire people all the time with state IDs without a driver's license. If you were to test right now, sir, what is in your system?
Marijuana and probably beer.
Do you have a prescription for marijuana, sir?
Years ago, before it was even legal.
Okay, so currently it's not valid, correct?
Yes, ma'am.
Okay, and so, who is Miss White to you?
That's my son's mother.
Okay, do you reside at that home?
Yes, ma'am.
Okay. Have you ever failed to appear in court for any reason, sir?
No, not that I know of.
All right, well, the court has some significant concerns for the safety of the victim in this matter, based upon the allegation in the police report. The court also has concerns that there's not another address that Mr. Shelton is able to provide with where he would be able to reside other than Orange Street. The court also wants to make sure that Mr. Shelton's going to appear in court.
I will. With no problem. I will.
Well, we had a matter here from 2022 that it took you 3 years to handle, sir, before you came back to court. And so the court's going to order, based upon all that, the court's going to order a $15,000 10% bond with the following bond conditions. You are not to have any contact with Alexandra White, no phone contact, text message, email, social media, third party. At this point, you're not even going to be contacting her or having a third party contact regarding anything with your children. The court's going to also order you not to enter the property on Orange Street. You are allowed one visit to obtain personal belongings so long as you're accompanied by a police officer. That means you contact the Wyandotte Police Department before you approach the home and you go with them to the home. You are not to possess or consume any alcohol or drugs that are not prescribed. You're not to possess or have access to any firearms or any weapons. And you are not to be released without a GPS tether through Wayne County Jail. Any questions?
But the way I make money is at her house. My phone is at her house. So it's like, is it something y'all can do? Cause I got like $2,000 worth of tools at her house that I make money with.
So
and I got my phone there.
I've just indicated you're not to have contact with her. I've also indicated you may go to the home to obtain personal belongings one time accompanied by the police officer. So that phone would be considered personal belongings.
Well, I can't call y'all if I don't have my phone, man. That's all I'm saying. I can't call if I don't have
Sir,
my phone.
contact your brother. You work with your brother. I presume you would know his phone number. We'll see you back on February 12th. Have a good day. We are on the record in
The question of course is, does the entrepreneur on the come up have a cell phone with which to contact? I have no idea. Let's continue with Judge.
If you're going to my client approach and stands to my immediate right, sir, can you state your name for the record? Your voice out? Yep.
Michael Chevette. All right, thank you. Please keep your hands out of your pockets. And you probably win the award for the oldest case today. Sir, these matters are from 2016. So I'm glad that you're here to take care of these today. Counsel asked the arraignment.
On both cases, you made formal reading. My client stands muted.
Court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and as to the pretrial.
Your Honor, we were able to work with a resolution in which the case ending in 3049 driving license be dismissed in exchange for my client tendering a guilty plea to a lesser included charge of allowing an unlicensed person to drive in case number 16-1463.
Okay, well, I have that, I have it reversed. I have 1463 is dismissed and 3049 is allowing licensed driver to drive.
Judge, and that reflects offer that the prosecutor is tendering and we are prepared to accept.
Sir, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right, and you heard the very generous plea your attorney was able to work out for you, correct?
Yes.
As to the amended charge on 3049 of allowing a licensed driver to drive, how do you plead?
Yes.
You've gone over your advice and rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No, Your Honor.
All right, counsel, if you can please vote to your client.
Your Honor, may I have the date of the offense on the 3049, please?
August 29th of 16.
Legislature to August 29th, 2016. Were you operating a vehicle in the city of Riverview?
Yes.
And when pulled over by the police and asked to provide a valid driver's license, you were unable to do so. Is that accurate?
That's correct.
So in the sense you allowed yourself to drive knowing that your license was not valid at the time, correct?
That's correct.
And you do have a valid license today. Is that accurate?
Yes. That's
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge on 3049. The court will dismiss the matter on 1463. Sir, there will still be, I believe there's a warrant fee and clearance fee on that one that was dismissed. As to sentencing on the 3049, counsel.
Yeah, and I asked my client why he took so long for him to come to court. He indicated that he did have some outstanding issues, and admittedly so, he lost track of this particular case. But when he went through the arduous process of getting his license back, he did notice that these were outstanding warrants, and he took it upon himself to make the necessary arrangements to come to court. It's my understanding that he has a strong family support system, a valid driver's license. I respectfully request that he be given cost and fines, and if necessary, a payment plan. Thank you, Judge.
All right, thank you. And sir, your license is valid today.
yes.
And are you on probation or parole anywhere, sir?
Nope.
Do you have any other matters you're out on bond for?
No.
Okay, the court's going to order 3049 statutory $100 fee, cost of $200, victim assessment fee of $75, justice system assessment fee of $50. That's for a total of $425. Is there a warrant fee and clearance fee?
Yes, $50 warrant, $45 clearance.
Okay, so then the balance on those is, that one's $520. You did post a bond of $500, less than 10%, so there's a $450 balance. Bond balance that we can apply, which would leave $70 still due and owing. And since you posted a bond on your other matter, there should be that difference to be applied on the 3049. Is there a clearance in the warrant fee on the other one as well?
Yeah, $100 warrant, $45.
Okay, so that's a total of $145. And again, it was $250 bond, less than 10%, leaves a balance of $225. So you're right about that dollars that can be applied. So you may not have to pay any money out of pocket. Okay, so just have a seat and somebody will be with you shortly, okay?
All right, sounds good.
Thank you, Judge.
Good luck to you, sir.
Thank you.
Okie dokie, let's stay in Michigan, but we'll go to Judge Elmore's court. Go back there. I do need to step out of the studio for a couple minutes. I will be back.
For the record now, taking up two cases. Each case is entitled People of the State of Michigan versus Michael Dean Woodworth. The first file is file number 25-3630FH. And the second file is 25-3650FH. Each one of them have a different defense counsel. But let's go ahead and start with appearances from the prosecutor.
Here, I'm David Denhousen on behalf of the people.
Robert Hack is appearing on behalf of Mr. Woodworth in 3650FH.
Copy that.
And good morning, Your Honor. Harian Yegos appearing on behalf of Mr. Woodworth on the other file on the record.
Thank you. That's 365 or 3630. And also joining us from the Missaukee County Jail via Zoom is the defendant, Mr. Michael Dean Woodworth. Mr. Woodworth, are you able to see and hear the court?
Yes, I am.
All right, thank you. All right. We are here today for a final pretrial conference on both files. However, I note that Mr. Niegos, for his file, which is file 3630, has filed a motion to adjourn that trial, which is currently set on, what date? It looks like it's February. It's our next trial date. Mr. Niegos, you still have this vacation lined up?
I do, Judge. However, we did communicate with Ms. Hagstrom last week. And the reason both Mr. Hackett and I are present via Zoom for today's final pretrial is due to the fact that we've reached an agreement and we sent in the paperwork for a plea.
Oh, hold on. You know what? It's probably all right here, and I just didn't. Okay. All right, they are. All right, Mr. Denon, why don't you start with 253630, which is Mr. Niegos's file.
Thank you, Your Honor. As part of that file, that is incorporated into the anticipated plea agreement. So the 253630 would be dismissed. If I may talk about the plea agreement in 3650.
Sure. So let's talk about 3650, acknowledging that part of the pretrial agreement is a dismissal of 3630. Go ahead.
Thank you. In that file, again, 3650, it's my understanding that the defendant will plead guilty to an added count of possession of meth. That would be an added count 2 under MCL 333.7403 2BI. In exchange for that plea, the prior count as well as the enhancements would be dismissed. The other case referenced at 253630 would be dismissed. I would note that there is a misdemeanor file, driving while license suspended, 251214 ST. That is in the district court. That would also be dismissed.
That number again, 25.
Yes, I spoke quite quickly there. 251214 ST, that's a driving while license suspended in district court. That case would be dismissed as part of this plea agreement. And lastly, as part of this plea agreement, there is a 1-year jail cap at the time of sentencing. I've anticipated the projected guidelines at 10 to 23 months.
Okie dokie. All right, Mr. Hackett, is that your understanding today?
Yes, it is, Judge. It's a complete and accurate statement of the plea offer.
And Mr. Niegos, who, by the way, is wearing Hope College colors. Good job. Go Dutch. Anyways, is that a complete and accurate statement of the pretrial agreement as you understand it?
It is, Judge. Thank you.
All right, thank you. You didn't go to Calvin College, did you, by the way?
I did not, Judge. I went to Spring Arbor College.
Okay, well, that's all right, as long as it wasn't Calvin. All right, Mr. Woodworth, have you heard what the attorneys have all told me is a pretrial agreement today?
Yes, I have, Your Honor.
Is that how you wish to resolve these two files?
It is.
Please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. All right, Mr. Woodworth, I'm going to ask you a lot of questions here, and I'm also going to go over your rights. The first question is, looking back on July 6th of 2025, hold on. Oh, wrong one. On June 17th of 2025, were you on probation or parole at that time?
No, Your Honor.
Were you on bond pending any felony charges at that time?
No, Your Honor.
All right. Now we're going to go over the terms of this pretrial agreement. Next, in the file to which you are pleading guilty and to at least one charge, which again is 3650. And that is the one for which you are represented by Mr. Hackett. In that file, you are charged on count 1 with delivery of the controlled substance, methamphetamine. Now that's a felony punishable by up to 20 years and or up to $25,000. Now there are 2 potential sentencing enhancements that could be applied within the discretion of the court if you were found guilty of that charge. The first is called a second or subsequent drug offender. That means that the maximum punishment could be increased from up to 20 years to up to 40 years, and from up to $25,000 up to $50,000. Or in the alternative, you could be sentenced as a 4th habitual felony offender. Now that could have increased that maximum punishment from up to 20 years to up to life. However, all of that will be dismissed if you enter a plea of guilty to, and I accept that plea, to an added count 2. Added count 2 would be a charge of possession of methamphetamine. Now that's a felony punishable by up to 10 years and or up to $15,000. And there would not be either one of those 2 enhancements that I already talked about, because those are being dismissed. So far, do you understand what's happening in that file?
Yes, I do, Your Honor.
Now, there's another term or condition regarding just that file, and that is that there's an agreement between you and the prosecutor about sentencing. Now, we need to talk a little bit about what that means. Now, first, it's an agreement that there would be a jail cap, which means I could sentence you up to 365 days. Now, by the way, that's in jail, and you would also receive good conduct time of 5 days a month versus a prison sentence where there wouldn't be good conduct time awarded. So that's a benefit. Now, this agreement is what's called a kilobrew agreement. It's important that you understand what a kilobrew agreement means. See, right now, I don't really apply any judicial discretion, right? The 2 attorneys, parties come to me, tell me what they want to plead to. I'll take the plea. If you state enough facts that make you guilty, then I accept the plea. It's when we come back for sentencing that I, as a judge, finally get to apply my discretion in reaching a sentence. Now, a kilobrew agreement means that you and the prosecutor have reached this agreement, but I haven't committed myself to it yet. Why? Now, there are these things. There's something else called a Cobb's agreement. A Cobb's agreement is where I would agree to it right now, but I don't do those. The reason why I don't do them is I may not know much about the defendant, right? So later on, I might get a police report that might, or a pre-sentence investigation report that will describe that you've got 100 different criminal convictions, you're wanted all over the world. I don't know. So that's why I don't commit to it. However, if at the time of sentencing, I do not go along with that agreement, you would have the right to withdraw your plea and come back to this stage of the proceedings. Do you understand?
Yes, Your Honor.
All right. Now that should cover that file. Now, if you plead guilty to that charge and I accept it, then you're getting benefits into 2 other files. The other file for which we're here for today, which is the one for which you are represented by Mr. Niegos, that is file 3630. In that file, you are charged with count 1, flee and elude a police officer in the 3rd degree. That is a felony punishable by up to 5 years and or up to $5,000. Additionally, the Secretary of State would suspend your license. Now, there is a 4th habitual felony enhancement there that would, within the discretion of the court, allow that maximum punishment to be increased from up to 5 years to up to life. However, that count is being dismissed. Count 2 is operating a vehicle while your license is suspended, denied, or revoked. That's a misdemeanor punishable by up to 93 days and or up to $500 plus vehicle immobilization. That count will be dismissed. Count 3 is a charge of obstructing, resisting, opposing, or endangering a police officer, specifically Deputy Sheriff Mitchell Vanderhoff. Now that is a felony punishable by up to 2 years and or up to $2,000. Plus, as a fourth habitual felony offender within the discretion of the court, that maximum punishment could be increased from up to 2 years up to 15 years. But all of that will be dismissed. Do you understand that so far?
I do, Your Honor.
Now, I told you that there were two other files that you were getting a benefit from. Now, the other file isn't before me because it's just a misdemeanor case. And it is case number 25-1214-ST. And that is a charge pending in the 84th District Court for a misdemeanor. I think you told me that was another driving license suspended?
Yes, Your Honor, 1 count, yes. Which
Which is also a misdemeanor punishable by up to 93 days and or $500 plus the vehicle immobilization. But that count will be dismissed as well. You understand that?
I do, Your Honor.
Okay. Now, by entering the plea in the file for which Mr. Hackett represents you on, if you enter that plea, you'll not have a trial. Does that make sense?
Yes.
If you enter a plea of guilty in that file, you'll be given up certain rights that you would otherwise have at a trial. Now, that includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses, the right to have the court order any witnesses you need to appear at the trial, the right to remain silent during the trial, the right to not have a silence used against you, the right to call witnesses if you chose to do so, and the right to testify if you chose to testify. Mr. Woodworth, do you understand those rights?
I do, Your Honor.
And even more importantly, if you enter a plea of guilty today, and I accept that plea, you will be forever waiving those rights as they apply to this particular case.
Yes.
Additionally, any appeal as to the conviction and sentence pursuant to this pretrial agreement will be by filing what's called an application for leave to appeal and not an automatic or claim of appeal by right, which is only guaranteed to a defendant when he or she is convicted at a trial. Also, furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You will also be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me right now on the record. Other than the terms of the pretrial agreement that we have gone over, have there been any other promises, threats, or inducements to entice or get you to plead guilty that we haven't discussed today?
No, Your Honor.
Now, you have met with both counsel, whether it's in person or via Zoom, to talk about this plea trial agreement. Is that correct, sir?
I have, sir.
And you feel like they've gone over the charges, your rights, and all the possible consequences and sentences with you?
I do.
And have they been able to answer your questions for you, if you had any?
Yes, they have.
And are you satisfied with their representation today?
I am.
Now, there's this thing we've already talked about regarding sentencing. We talked about a jail cap of up to a year. The prosecutors told me that he estimates this thing called the sentencing guideline range to be 10 to 23 months. Number one, has anyone made a promise to you as to exactly what the sentence would be?
No, Your Honor.
Okay. Number two, on this form that I see here that the attorneys have presented to me and signed, it says the word estimate. So I just want you to understand that that 10 to 23 is just an estimation of what that range will be. And we'll find out what the actual range will be later when we come back for sentencing. Do you understand?
I do, sir.
Next, I want to tell you is that the sentencing guidelines in the state of Michigan, which recommend a minimum range for only felonies, is just that. It is a recommendation. The guidelines are not mandatory. They are, however, a tool that the courts must use, but it's not mandatory. It is up to the court to establish an appropriate sentence under the law that is proportional and reasonable to the case. Do you understand, sir?
Yes, I do, Your Honor.
Do you have any questions of me before I take your plea, sir?
No, sir.
All right, in file 3650, as to the added count 2 of possession of the controlled substance, methamphetamine, how do you plead?
Guilty, Your Honor.
Now, before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. Turning your attention back to June 17th, 2025, in the city of Lake City, here in Missaukee County. What happened? Did you have a run-in with law enforcement?
No. I finished working for that day, and me and a CI in this case had both indulged in the use of methamphetamine, and I possessed methamphetamine at that time.
Right. And was it here in Lake City?
Yes, it was.
And in your mind, did you have any lawful right to possess that substance?
I did not.
And did you know that it was methamphetamine that you possessed?
I did.
All right, thank you. Mr. Denhoughton, are you aware of any other, I'm sorry, do you believe the defendant provided the factual basis to support the plea?
I do, Your Honor.
Are you aware of any other promises, threats, or inducements that we haven't discussed?
No, Your Honor.
And do you believe that thus far the court is in compliance with Mission Rule 6.302?
I do, Your Honor.
Mr. Hackett, do you agree with all three of those statements?
I do, Judge.
Mr. Nagos, do you agree to all three of those statements?
I do.
Thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfy the elements for added count 2. Therefore, the defendant is found guilty of added count 2. The other original count and enhancements, as well as the other file 3630, will be dismissed at the time of sentencing. At that time, Mr. Woodward, sentencing will generally be in about 4, maybe 5 weeks at the longest. Between now and then, an agent from the Michigan Department of Corrections, which is also known as the Probation and Parole Office, they will prepare what's called a pre-sentence investigation report. One of these reports must be prepared anytime someone's convicted of a felony in a state court in Michigan. Now, because I know that you have some prior felonies on your record, you've already done this before. There are 3 steps that involve you. Number 1, you will receive a packet at the jail. You will complete that packet and turn it in to the department. Number 2, you'll have an interview with an agent from that office. And because Mr. Hackett is the one that represents you on this file, you'll have the right to have him present during that interview. Number 3, Mr. Hackett will have to meet with you and go over the contents of that report prior to you two appearing in front of the court for sentencing. Why? Because you each need to go over it and make sure all the information is correct. Each side has the right to come to this court, request corrections, request amendments or challenges to the guidelines, things like that. So that's why you need to talk to them thoroughly. Now, Mr. Hackett has appeared in front of me several times before, and I don't know if I've seen you, so I apologize if I have and I don't remember. However, pre-sentence investigation reports, they largely take old reports and then they add to them. I do not like passing other people's junk, which means if there are any errors, even if they were appeared from a previous case, I like to get those corrected because these documents follow people. And if we can correct them, then we don't pass any junk forward. Does that make sense, sir?
Yes, it does.
All right, Mr. Woodworth, we're about to wrap up. Do you have any questions of me about what we have done today?
No, Your Honor.
All right, because of what I've heard, the potential sentencing guideline range will be, the court's going to revoke bond, remand the defendant to the custody of the jail. Mr. Woodworth, have you been into inpatient programming?
No, Your Honor.
Okay. Mr. Hackett, since this is your file, I'm not advising you, but are you appointed on this, sir?
No, Judge, I'm retained.
If you are able to work with, say, the public defender's office and get him into a treatment program, I am often willing to adjourn sentencing, release a defendant on a PR bond to that program. And if that person leaves the program involuntarily or is ejected from the program for failing to comply, then that person must turn themselves into the jail. And here's the key. If you are able to get them into a program, normally they're inpatient programs, as you know, for not 30 days. And then most of the programs will offer a 90-day sober living facility option. I am very willing to give somebody the opportunity for rehab, especially if they have not had it in the past. And I'm also very willing to adjourn sentencing to allow a person the benefit of that program. In other words, the full 120 days. Now, when you've got a case who has a straddle cell like this, a 10 to 23, well, where I sentence the person, whether I give him the jail cap or if I even go below the 10, depends on whether or not somebody does the program and completes it. So what I'm trying to say to everybody is I'm not rejecting the cap. I don't know what I'm going to do. I don't remember Mr. Woodworth from anyone else, but you had a 10 to 23, and whether or not I give him 13 to 14 months is a pretty substantial gamble. But if you are able to help get him into a program and he proves himself, does everything the program asks of him, then he's got a lot better chance of getting the cap. And he even has a better chance of getting less than the 10 months. So that's not a promise to anybody. Yeah, it's not a promise, but you know, Mr. Woodworth, lots of people love to come and say, well, I never got rehab, or I just want rehab. Please give it to me again. Well, I often send them to programs and part of their probation, and they often disappear. So I'm willing to let somebody go to a program, because if they fail to appear and they fail to go to the program, all I've got to do is issue a bench warrant. The likelihood of getting prison goes up. Now, that's not a threat. That's an enticement to help get you into the right programming. So, Mr. Hackett, really encourage you to call Mr. Champion to see if he has any suggestions. We have a pretty good relationship with Addiction Treatment Services up in Traverse City. Ms. Lipinski up there does a really good job of helping get people into beds. All right. Anything further, Mr. Denham?
I was just going to say that just for the record, I would support those efforts. And, you know, we might have to tweak the wording a little bit, but I would be highly inclined to sign a proposed stipulation if a bed is found.
Mr. Hackett, Mr. Denhoughton over here, Ms. Carey, and those over in Wexford, and especially those in the Public Defenders Program can walk you through exactly what I want to see in a stipulation. And what I will do is, if you all give me a date, I'll say on that date, his bond is modified to a PR. He must report by noon. And by the way, we offer free rides through what's called Wex Express, which is our local transit. And so they come right to the jail, pick them up, take them there. It's easy peasy. All right. Mr. Nagel, anything further, sir?
No, Judge, thank you.
All right, folks. Thank you very much. We're adjourned.
Thank you for the direction, Judge. Michael, call me after 4. Thank you, Judge.
Yep.
Can we go back to the prison so we don't lose Mr. Bond?
Yeah. You're in charge over there.
Okay, friends, programming note, you know, normally during the 4th hour I do discussion, commentary, stuff like that. I'm just going to run with court for the 4th hour. And the reason being is we've got a crew here at the bunker today that's working on multiple things around the house, and I don't want to be mid-conversation with you and get pulled away from that because that's just overly disruptive. So for the 4th hour today, we're just going to continue with court. And I think we'll continue with Judge Elmore here for a minute. He's got a new contestant, and once again, I need to step out. I'll be back shortly.
Our next file here is People of the State of Michigan versus Jonah Vaughn. File number is 25-3632FH. Appearances from counsel, please.
Thank you, Your Honor. David Denhoughton on behalf of the people.
Robert Hartzell from Mr. Vaughn, who joins us by Zoom from prison. Your Honor, I am filling in for Ms. Fiobento.
Thank you. Mr. Vaughn joins us again from a Department of Corrections facility via Zoom. Sir, are you able to see and hear the court?
Yes.
All right. Without getting into any details respecting the privacy of Ms. Fiobento, there was a family issue So that's why she's not here. I don't want you to think that you've been shoved off on somebody. It was something that popped up over the weekend, as far as I understand. So anyways, so we're here today for a final pretrial conference. Do we have a resolution?
I believe we do.
All right, Mr. Hartel, do you know what it, do you agree?
I agree, Your Honor.
Right, thank you. All right, so Mr. Vaughn, I'm going to hear from Mr. Denhout what he believes to be the resolution today, and we'll come right back to you. Yes, sir.
Thank you, Your Honor. It's my understanding that Mr. Vaughn will be accepting the people's offer, which is to plead to count 1, 2, and 3. Those counts are count 1, fleeing in the 3rd degree. Count 2 is resisting, obstructing, and count 3 is separate, resisting and obstructing. In exchange, count 4 would be dismissed, and importantly, the habitual 4th notice would also be dismissed. Now, as part of this plea agreement, just for the sake of context, the defendant is currently serving a prison sentence with an anticipated out date of May 21, 2027. So in terms of a kilobrew, we are agreeing that when the defendant is sentenced at that time, from that time forward, we would agree to concurrent sentencing. Now, as not a kilobrew agreement, it would be our recommendation to not, the people would at the time of sentence be arguing to not move the current out date for the defendant, but that's not a kilobrew. That would be our recommendation at the time of sentencing.
All right, that's a bit confusing, but I'm going to see if I can take a stab at just repeating the words that I understand and make sure everybody else does. So regarding the sentence, and besides whatever the charges are, 1, 2, and 3 is pleading guilty to, dismissal of count 4, and dismissal of the 4th habitual enhancement. And when you say concurrent sentencing, so let's say we come back here in March. Do you mean give him credit for the time that he's serving, like in my mind, or?
So, so in terms of a kilobrew agreement, my understanding in terms of the law, because he's serving a current sentence, that legally, and obviously the court can make some sort of internal calculation, but what we're saying is that from the time of sentencing on, that this sentence would be concurrent with the time of his MDOC, which is what I think typically what the court does, and I think is legally allowed.
So, yeah, I got it. Yeah, I agree. All right, I just want to make sure I understood that. So if he gets sentenced, let's say, for example, on March 1st, I don't know if that's the date in which we're in court, that time runs concurrent with whatever he's serving. But what he's getting there right now, he doesn't get any credit.
That's correct, John.
Great, thank you. Mr. Hartel, is that what you understood?
Yes, along with just the recommendation still, but yes, Your
Yeah,
Honor.
I got it. All right, thank you. All right, Mr. Vaughn, have you heard what the attorneys have described to me as the pretrial agreement today?
Yes,
Is that how you wish to resolve it, sir?
yes,
Please raise your right hand, sir. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
yes, sir.
Thank you. Mr. Vaughn, looking back on this date of July 31st of 2025, which is the alleged date these offenses occurred or allegedly occurred, I take it you must have been on parole at the time?
Yes, sir.
And is that, so you've been violated on parole and drawn back into the Department of Corrections for that, is that correct?
I am on the back on a new case. I had a gram of weed on me in Clare County Jail.
Okay, so you have multiple new cases, this one, and then the one out of Clare County that has caused you to be violated on your previous parole, and that's why you're there at the Department of Corrections. Did I get that right?
Yes, sir. Yes, sir.
All right, thank you. Were you on, back on that date, were you on bond pending any felony charges anywhere?
Yes, out of Clare County.
Okay. So the Clare County one that you're there for a probation violation, you had a bond for that felony case, is that right?
Yes.
All right. Have you already been convicted of that file?
I am now, yes.
Okay. So this is going to cause a little further explanation, which is perfectly fine because it shouldn't impact your deal. And I'll go over the deal in just a moment. What happens here is if you are on bond pending a felony case, and then you pick up a new felony, and sometimes there is what's called mandatory consecutive sentencing, and sometimes there is discretionary consecutive sentencing. So because you've been sentenced on that prior of that felony for which you were on bond, any sentence that I would give you here could, within the discretion of the court, run for that that marijuana case, sir.
20 months.
All right. So I could, within the discretion, within my discretion under the law, tack on any sentence here to the end of those 20 months. However, as I understand it, the agreement that Mr. Denhouten described to me is I'm not going to do that. Is that correct?
That is the agreement.
All right. I just want to make sure we're all on the same page. And unless it's a mandatory discretion, I'm sorry, not mandatory discretion. That's a redundant. That doesn't make sense. Unless it's mandatory, I probably wouldn't do it anyways. But all right. So let's talk about this plea. Count one is a charge of fleeing and eluding a police officer in the 3rd degree. Now that is a felony punishable by up to 5 years and or up to $5,000 plus the Secretary of State would suspend your driver's license. Now there is a 4th habitual felony enhancement that could have increased that maximum punishment from up to 5 years to up to life. However, the enhancement will be dismissed. Count 2 and count 3 are both charges of assault, batter, wound, resist, obstruct, oppose, or endanger a Michigan State trooper. In each of those, the maximum punishment is up to 2 years and or up to $2,000. And because there is that 4th habitual enhancement, the maximum punishments could have been increased up to 15 years for each of those 2 counts. However, while you are pleading guilty to those 2 counts, the prosecutor agrees to dismiss the 4th habitual enhancement. Count 4 is a charge of reckless driving, which is a misdemeanor punishable by up to 93 days and or up to $500. That will be dismissed. So far, at least regarding the counts, is that what you understood to be the terms of your pretrial agreement?
Yes, sir.
Okay. Now there's another portion of this agreement that's called the Killebrew Agreement. And while you may be aware of it, I need to explain it to you. A Killebrew Agreement is a sentence agreement that you reach with the prosecutor. I am not a party to that agreement yet. I will decide at the time of sentencing whether or not I will follow it. Now, if I don't, you would have the right to withdraw your plea and then come back to this stage of the proceedings. Now, that Killebrew Agreement is that whatever sentence you receive, it will begin to run concurrent with whatever you're currently serving. In other words, that discretionary consecutive sentencing I talked about a minute ago, that's basically what this means. It's not going to be consecutive. It's agreeing that it's going to run concurrent from that date. Does that make sense, sir?
Yes, sir.
All right, thank you. Now, by entering the plea of guilty to these 3 counts, you will not have a trial of any kind. Does that make sense, sir?
Yes, sir.
That means you'll be waiving certain rights. That includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you chose to testify. Mr. Vaughn, do you understand that if you plead guilty and I accept that plea, you will be forever waiving those rights as they apply to this particular case?
Yes, sir.
Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement would be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would only otherwise be appealable if you were convicted at a trial. You also will be given up the right to come back and claim that the plea was a result of any promise, threat, or inducement not told to me today on the record, or that the plea was not of your own free choice. Mr. Vaughn, are you entering these pleas today of your own free choice?
Yes, sir.
Other than the terms of the pretrial agreement, which we went over, have there been any other promises, threats, or inducements to get you to plead guilty that we have not yet discussed today?
No, sir.
And I know we've talked about potential, well, actually, we didn't talk about the guidelines, but I trust that Ms. Firavento has talked to you about sentencing guidelines. I'll just highlight for you, as you may know, sentencing guidelines are not mandatory. They are a tool the court is required to use to establish a sentence, but we do not actually have to follow them. We just have to use them to try to establish a proportionate and reasonable sentence. Has anyone made any promises to you or suggestions as to exactly what a sentence would be from this court?
No, sir.
Now, have you had the opportunity to discuss all this with Ms. Firavento or Mr. Hartel?
Yep. Yes, sir.
And did he or she answer all your questions if you had any?
Yes, sir.
And were you satisfied with their advice, at least up until now?
Yep, very much.
All right, good. Thank you. All right. Do you still wish to enter the pleas that we discussed earlier, sir?
Yes, sir.
Thank you. As to count 1, 2, and 3, how do you plead?
Guilty.
Before the court can accept those pleas, the court must have you tell me what it is that you did that makes you guilty of those offenses. Turning your attention to July 31st of 2025 in the city of McBain in Missaukee County. What happened?
I was being pulled over and I did not stop. And they followed almost to my residence. And when they got me in, my door was open and I had a pair of scissors in my hand and refused to be arrested. So
let's see if I get this correct. You were driving a vehicle on a public roadway. Is that correct?
Yes, sir.
And you say they, you mean a couple of state troopers, or at least, was it one car or 2 cars?
One car.
Okay, and so was it a state trooper car, the blue with the cherry light on top?
Yes.
And did they turn on those lights or sirens, and in other words, try to give you direction to stop? All right,
Yes,
and you
sir.
saw those? I'm sorry, that's right. And you recognized that they were troopers trying to do their job to pull you over. Is that correct?
Yes, sir.
All right, but you did not stop the vehicle that you were driving. Is that correct?
Exactly.
Now, what makes this a flee and elude third versus a flee and elude fourth is the speed. Were you exceeding the speed limit in an area where the speed limit was 35 miles per hour or less?
I believe so, yes.
Where were you? Where was your house?
On the other side of Marion.
Yes, sir.
It was based on 2 bases.
Yep.
The court is right.
Uh-huh.
There was a section that was 35 or less, but also what might be a little bit easier is that
he had a previous one.
Yes, sir.
Yeah, that's the next question. Whether or not it was or wasn't, is it true that you also had a prior flee and elude over in I'm sorry, it was actually here in this county in front of me back on March 12th of 2021?
Yes, sir.
All right, thank you. Now, you said when you pulled into your driveway, you had a pair of scissors. What did you do with those?
I just grabbed them threatening to hurt myself.
All right, and so you were resisting those 2 police officers who were trying to take
Yes,
you
sir.
into arrest?
Yes,
Okay,
sir.
thank you. All right, thanks. Mr. Denhon, do you believe he's provided a factual basis?
Yes, sir.
Are you aware of any other promises, threats, or inducements?
No, you're-
And do you believe that I've complied with Michigan Rule 6.302?
Yes, sir.
How about you, Mr. Hartel? Do you agree?
I agree.
Thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that based upon the testimony made under oath on the record, satisfy the elements for the 3 counts. Therefore, the defendant is found guilty of count 1, 2, and 3. The case will now be set for sentencing, and at the sentencing, count 4 and the enhancements will be dismissed. Mr. Vaughn, I need to advise you, even though you probably already know, between now and then, we have to have a pre-sentence investigation report. Now, because you probably I know you've had prior ones, they'll basically take the most recent and they'll add to it. Now, that requires three things. They'll give you a packet, that meaning the Department of Corrections. You'll fill it out and turn it in. You'll also be subject to an interview, and you have the right to have one of your two attorneys present during the time of that interview. And number three, your attorney must meet with you prior to us coming back to court, because he or she must go over that report, because each side has the right to come back to this court and request corrections, make objections to the scoring or objections to the content, because we want to make sure that it's complete and accurate before the court gives a sentence. Now, Mr. Vaughn, I say this often, I don't mean to be rude, but I don't like passing other people's junk forward. So if you get this PSI and prior courts or prior probation officers haven't filled out all the information correct, well, I want to correct it. So if it's on an old case and you didn't have a probation violation, it happened in a different county, speak about that with Ms. Fierabento, because I don't want to pass anything forward, because these reports follow people if there's an error and needs to be corrected. Do you have any questions, Mr. Vaughn, about what we have done today?
No, sir.
All right, thank you very much. Anything further, Mr. Denon?
No, Your Honor.
And Mr. Hartel?
No, Your Honor.
The court revokes bond and remands the defendant into custody. Of course, he's now earning credit. All right, thank you all very much. We are adjourned.
It's TCF on a chaotic Monday here at the bunker. Lots going on. Glad to have you all here. Again, for our fourth hour, we're going to just continue with court as I keep getting pulled away, so not a good time to do discussion and commentary today. But, we've been promising 9 to 11% more Judge Boyd for like a year now, and it's been hard to show her the last week or so. But she's here now, so let's see what's going on.
I mean, we can. Okay, we're doing Jeremy for 2 minutes. Jerry. Okay.
All right, court is calling 2025 CR 015760 State versus Marcos Romero. Could I have parties announced?
Brandon Brady for the state.
Jose Rocha for Marcos Romero, Your Honor. Ready.
And are you Mr. Romero?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Romero, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Romero, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with theft of property less than $2,500 with 2 or more previous convictions. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Romero, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 1 year in the Bexar County Jail under 1244, and the state will take in consideration 2025 PF 36675. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor, it is.
Okay, is that the plea?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, reference exhibit number 1 and all of its attachments.
No objections, Your Honor.
All right, state you may be excused.
Good.
Did you review the waiver and stipulations with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor. Thank you.
All right. The court will sentence you to 1 year in the Bexar County Jail on a 1244, give you credit for any time served. Take in consideration 2025 PF 36675. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You've got to stop stealing.
Yes, ma'am.
If you continue to steal, what's going to end up happening, this is now a felony conviction. At some point, you're going to end up getting enhanced.
Yes,
If there's an issue where you don't have money for food, then there are plenty of places you can go. You can go to Haven for Hope. You can go to the food pantries at different churches. You can go to the food bank. You can go to the Salvation Army. But going into stores and stealing, that's not the way to do it.
Yes, ma'am.
Because guess what? What if everybody who had no money decided to steal?
Yes, ma'am.
And I always tell people, think, attorneys are wealthy, right? We're not. When I was in law school, guess what? I didn't have money to pay for food. Guess what I could have done? I could have stole. I could have stole out the vending machines. I could have stole from the cafeteria. But instead, I talked to the person who was the chef, and I said, look, I don't have any money, but can you give me food and I'll pay you at the end of the week? And guess what ended up happening? Sometimes I would end up paying him at the end of the week. Sometimes he's like, oh, Stephanie, you can pay me at the end of the month. My mom would send me money through the mail and I would pay. And if I would have stole, that's a crime of moral turpitude, and I wouldn't be where I am now because I just stole.
Yes, ma'am.
All right?
Yes, ma'am.
So stop stealing.
Yes, ma'am.
All right. Good luck.
Can I ask you?
Sure.
Get my time that I did.
You're concerned about time instead of that you've just been found guilty of a crime of moral turpitude. Let me just tell you, legally, I have to give you credit for any time that you've been in custody.
Please, thank you.
All right. Good luck to you.
Good luck. Thank you.
You're welcome.
Thank you, Your Honor.
Let me give you some advice. Don't steal. That's good advice, Judge Boyd. Let's stay in the South, but let's Louisiana. Parole board attempt number 2 for today.
Are you guys able to see me or?
Yeah, we can see you.
Oh, okay, gotcha.
Yeah, we got you. So would
Okay.
you introduce yourself? Tell us your name and DOC number, please.
Okay.
Sorry,
once-
not your DOC number, your current mailing address.
Okay, yes. Name is Richard Charles Reed Jr. Current mailing address is P.O. Box 78211, Seattle, Washington 98178.
Okay, so it's pretty early there for you, huh?
Yes, I think you guys are 2 hours ahead.
Okay, so you're here today, Mr. Reed. You're seeking pardon with restoration of firearms. I do have your DOC number as 397017. You were sentenced in St. Mary Parish. Let's see, you have sentencing date May 1998. Theft, 5 counts of theft. You received a 10-year sentence on each count that was running concurrently, but it was suspended and you were placed on 5 years probation. You also have a simple battery sentencing, same date. You received a 6-month parish jail sentence, and that was suspended. You were placed on 2 years probation. Does all that sound accurate?
Yes, that does sound accurate. Yes, yes, ma'am.
Thank you, sir. Your case this morning, Mr. Reed, has been assigned to Mrs. Stapleton, seated to my left. Would you answer her questions?
Good morning, sir.
Good morning.
Tell me something about the case. What happened 25 years ago?
So yeah, I had a fake ID and just had some checks that was made out to me, and yeah, just cashed them. I'm not the same man I was back then, and so pretty much I had a fake ID, had some checks that was issued out to me, and I just cashed the checks, and yeah, didn't work out in my best interest.
Okay. I read that you made restitution. Is that correct?
Yes, that is correct.
Okay. Let me ask you about one thing. I see that there was an see what I've got here. Let's see. I hope you get the restoration. Yeah. In 2002, there was a battery charge, 6 months. Tell me about that.
Battery charge. If the date is correct, I think me and one of my family members got into an altercation. Got pretty physical, and that is what led to the battery charge.
And so your probation was revoked in 2002?
No, actually, I left the state without knowing everything I had to do, like check in or whatever. Got arrested, and that's when I got extradited back to Louisiana. And I had to pay the entire restitution amount. And yeah, pretty much that's it. Had to pay the entire restitution amount in order for me to be released.
So actually in 2002, that's when you pulled everything together.
Yes, ma'am.
Okay. All right. Let's see. You got some, as far as like the assistant attorney general there opposed due to your probation violations and convictions in another state. The DA is also opposed for you to be granted with firearms. The other ones had no comment. And I've read that the reason you want it is to visit your family in Canada. Is that correct?
Okay, so yeah, I was going through the immigration and stuff also. I am allowed to now enter Canada. And as far as me wanting firearms, I mean, just protection for my home. I'm now a homeowner, and just pretty much to have a firearm in my, with everything that's going on in the world, just pretty much for protection. I'm 54 years old. I'm definitely not the man I was 20 years ago. And that's pretty much all the firearm is for, just for protection of my home.
Okay, I'm going to turn it over to my fellow board members. Any questions?
Any questions?
I have no questions.
Have you had any problems since then?
No, I haven't had any run-ins with law enforcement for over 30 years now, or close to. Been a law-abiding citizen. Like I said, I'm not, I can't say it enough. I'm not the man I was 30 years ago. But all that taught me a lesson, and it just showed me I have to be a lot more patient for things. I think I was just a lot of my stuff that I did when I was younger. I was impatient and just made a lot of bad decisions.
Okay. And that was in 2002, right?
It's been over 30 years since I had any involvement with any kind of law enforcement.
Okay.
Well, you had an arrest in 21, right?
No.
December of 21, it was, no, 2001, I'm sorry. So it's been 25 years since you've had contact with law enforcement.
Okay, and what was that arrest? What was that arrest for?
Possession of marijuana.
Okay, yeah, and which is now legal up here, but yeah, yes, that does ring a bell.
Does count as a contact. What do you do? What is your profession?
I am a truck driver.
Okay. All right, any other questions?
No.
I think we're ready to vote. Mrs. Stapleton?
Today I'm going to grant your request for a pardon with firearms.
Mr. Prater?
I concur. I think 25 years is, seems like long enough, something like he's straightened out, doing right.
Yes, thank you.
I grant with firearms.
And my vote is the same, recommend the pardon with restoration of firearms. So we are going to make that recommendation, Mr. Reed, on your behalf to Governor Landry. Good luck to you, sir.
Lindsay, you're wrong. They granted him unanimously. Of course, the on these cases the governor has to sign off, but they probably will. But I'll tell you one thing that gets my attention, and he did this just now, and we see it so often. Comments like, yes, that rings a bell when it comes to previous charges or convictions or run-ins with the law, however you want to put it, that these people have had. Whenever I hear that, it's a big point of hesitation for me. Don't tell me that you don't remember and that you don't know when you've had contact with law enforcement, when you've been in court, when you've been charged and or convicted of something. Because of course you have. Unless you've gone career. If you've gone career, then I can understand where you would lose track. I mean, I've gone career on YouTube here, and I can't tell you what I said a week ago on this channel because there's so much of it. So, unless that's the case, that's just a deflection. Drives me nuts. Anywho, Judge West.
All right, so Mr. Spites tested positive for THC, and so obviously sometime within the last 30 days or so, he's used marijuana, because typically that's how long, which means that he used marijuana after he pled guilty on a felony. He pled to an enhanced second degree. I've got pages of criminal history here. And you would think, Mr. Spites, that based on what Ms. Hawkins is telling me about your family situation and your children, that you would be able to figure this out on your own and stay clean so that you didn't, number one, go to prison. I don't even have to accept this plea agreement. I mean, you've got 3 prior convictions, a state jail felony from 2019, from 2019, credit debit card abuse from 2021, and then an unlawful possession of a firearm in 22. None of those cases did you receive probation, which is probably why Ms. Malfino made that offer to try to get you on the right track. And Ms. Hawkins did a great job of getting you a probation offer on your case or cases.
If I may,
Yeah.
part of the reasoning behind that offer that Ms. Hawkins and I discussed was that jurisdictional type issue that she addressed with the court, and also the fact that there ended up being no restitution that's owed to any individual.
Okay, and I appreciate that argument that Ms. Hawkins made, but it's also important, and I would hope that other judges in other counties would find it just as important, that if you're going to get charged, wherever you're going to get charged, that they take into consideration that just because you didn't steal from someone in our county, you stole from someone in some county, right? And so we got you here, but somebody's a victim. And it's important to me, and hopefully important to every judge in the state of Texas, that we kind of look out for each other in each other's counties. So I get that you were just traveling through, probably lucky that we got you, because who knows what would have happened at that point if you ever would have gotten caught. And that's not fair, no matter what county the crime is actually committed in. Does that make sense? Based on everything that is being offered to you and what the pre-sentence talks about with regard to drug usage, the only way I'm going to go forward with this is with some inpatient ISF up front. So it's not necessarily meant to be a punishment. It will probably feel like it a little bit, but if you're going to be successful in the rest of your life and be there for your children, then you got to figure out how to stay clean and make some better decisions. So that's what's going to happen today. Any reason not to go forward with sentencing at this point?
No, Your Honor. No, Your Honor. Just my only concern with that is the other pending cases in Fort Bend and Jackson County. I don't know if I simply take it.
What are the court? Or do you represent them in Fort Bend?
Not
and
Fort Bend, Judge, no.
what about the Harris County,
I do represent.
that evading?
I do represent him in Harris County.
I just don't, trying to think of logistically, because I mean, one thing that I can do, I'm just not inclined to let Mr. Spites walk out today on a probation when he tests positive with this kind of history and with technically 4 felony cases pending in 3 different counties. So,
I have to ask Judge, my next question was gonna be, is there typically a report date that could be given for ISF from the attorney's
no,
office for it?
no. And so what I'm going to do is I'm going to order it. And then once he's in custody, if you'll let obviously Harris County know that he is in custody. And if they will put a hold on him and come get him, I'll release the ISF hold while he goes and takes care of with that. Same thing with Fort Bend. But then if those are going to be probations or whatever happens, we'll put our hold back on once he's gone. So that when he finishes those counties, we've still got him for ISF. Sometimes what happens if that process takes a really lengthy time, then potentially if I feel like it's a good enough time, then I can hold that at abeyance at that point and require something like JCDI, which is outpatient. But based on the positive drug screen today and based on this criminal history and what all's pending, he's not walking out of here today. So we'll do it that way. If you'll get with his attorney in Fort Bend County, the sooner they get something set and get a hold on him, the better. Okay, that way he can get transferred, get those cases taken care of.
And I'll reach out to those DA offices, Judge.
Perfect.
Maybe with the court's order, they would be willing to negotiate their
Something
cases.
quickly.
Yes.
So, Mr. Spites, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine. There is no restitution. And you're ordered to enter and successfully complete. Mr. Spites, talk to her in a minute. Just listen to what I'm saying, okay? You're ordered to enter and successfully complete the substance abuse track of the ISF program. And if you do all of this, this is a great opportunity for you. I know it doesn't feel like it today, but you have a great opportunity in this case, number one, without another felony conviction, and to be able to serve any sentence while you're out on probation. I want you to make sure you understand, though, what the consequences could be if you violate this probation. So if you choose to smoke marijuana again, or not show up for an appointments, or whatever it is, then you're looking at not just a sentence of the theft of property, which is the 3rd-degree felony. You pled to an enhancement, which means if you violate, you could be found guilty and sentenced to prison for anywhere between 2 years and up to 20 years. So I'm trying to keep that from happening and give you some tools so you can be successful. I'm handing you the trial court certification that shows this was an agreement. I followed it, and so you've waived your right to appeal. You can go back with the bailiff. Ms. Hawkins can visit with you back there, okay? Yes, sir?
Okay. The fact that, okay, all right, y'all taking me in. That means like I can't get out from here. How can I get out so I can be able to handle Fort Bend?
We're gonna let them know that you're in custody, and they'll come transfer you over there from our custody.
Okay, so that's what I'm saying. That's what I'm trying to understand. Okay, if I'm on bond with them, like how would that work?
Ms. Hawkins can explain it to you, okay? All right, you can go back with the bailiff. Thank you, Ms. Hawkins and Ms. Morfino.
All right, let's stay in the building, but go next door. New contestant with Judge Stevens.
Okay. 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 Yes. Okay, I've got. This motion needs to be in this file.
Yes, Judge, there's a new case and a motion to revoke. There's only one motion to revoke case.
This didn't make any sense at all, but it's because it's supposed to go in that file. And then this goes in this file, and this one goes in this file too. And this one in this file. All of these go in this file. Weird. Hey, present report, please. Do you happen to have it in the file? Thank you. So I need a public safety report. I'm sure it's. He's asking for a bond. I don't have a public safety report. That has to get prepared. I can't do it without a public safety report.
Judge, for some reason, we don't have one in this file. We'll have to reset the case. I can't get it right now.
Okay. I have to reset it.
Do it pretty quick, Your Honor, because.
Yeah. It doesn't take long. It doesn't take long to get one, but let me just look at something here. All right. We are dealing with a case where the defendant was placed on probation in September, over a year ago for 5 years. And then that was on September 10th of 24. So he's charged with evading arrest or detention on April 26th of last year.
Yes, sir.
Failing to work faithfully at suitable employment, providing urine sample testing positive for cocaine in October. Urine sample testing positive for tetrahydrocannabinol in June. Failing to provide verification of performing community service hours. Failing to intoxicating substances. Let's see. In arrears on restitution. How much is he paid in restitution, please? That's important to this court. Failed to pay assessed fees as well. is in $7,506 arrears and all of that.
Restitution, he's $533.
Which is so what did it consist of? What was the restitution?
The total.
No. What what were the acts that caused the restitution? Was the misuse of the credit cards?
I believe so.
Yes, sir. How did that? Okay. Okay, so at the end of the day, I guess it's going to be the vendor that accepted the credit cards for payment, not the person who was defrauded, I guess. Is that right? Is that the recipient goes to vendor merchants? Because the ones that are going to be out the money.
Should be in the agreement. Plea agreement.
So he's paid $543 since he's been on
Yes, sir.
Probation. But
Yes, the restitution was to the financial institution.
That is our understanding, Your Honor.
the card entity,
Yes, sir.
Bank of America to be exact.
but he's also committed, allegedly committed at least 3 more crimes while on this court's watch, right? 2 drugs and evading arrest or detention with a motor vehicle.
He's talking about the attorney emails.
All right, we're gonna have to give us 48 hours. Okay, we'll reset a few days. Thank you.
I appreciate you.
Thank you. Yes, sir. Deanna Preston. What are we doing? What do we do?
5 deferred on the state jail.
What's a disposition?
Yes, sir. 5 deferred restitution. Easy.
Okay, well, you need another pad.
Judge.
Is that it?
I thought we just go back to payments.
Let's see. That's
quicker. Yeah, she's the back. I'm sorry. Yeah, she's the back. This president. That's it. I think. Is the only back yet?
Vacation.
Okay.
No,
She's back.
no, she's not back.
Need to confirm my vacation dates for Army.
Oh, I got the email from.
I'm confirming travel dates right now to make sure I'm all. So,
Yeah, I got your email.
okay, no
I
worries.
just haven't. Okay.
No worries. I just want to, at some point, I'm waiting for them to reply back to make sure I cover my travel dates. Yeah, we're good.
Okay, ma'am.
You gotta go check that print.
There's the right hand, please. You swear or affirm to tell the truth, whole truth, and nothing but the truth, self you got? Yeah. Okay, you got your right thumb print. Place it flat right there on the box. Can you get up one more time? Place it right there. Go stand in front of judge, please.
Consumer service.
We now call cause number 24 feet R1691, the state of Texas versus Deanna Lynn Ortiz Preston. Is that you?
Yes.
With Mr. Turk, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about April 27th, 2024, in Jefferson County, Texas, it alleges you committed the state jail felony of theft of property of a value of $2,500 or more, but less than $30,000. Do you understand what you were charged with?
Yes, Your Honor.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 5 years. Most importantly, you must pay the victim back $5,200. Is that your understanding of the agreement?
Yes,
If I follow this, you have no right of appeal. Do you understand?
yes,
How do you plead to this, guilty or not guilty?
guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Y'all having a good time over there? I'm going to ask you to read that. That states Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
States Exhibit 1 is tendered into evidence and without objection. No objection. It's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's voluntarily and freely made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 here, admitted to find you guilty beyond a reasonable doubt. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Correct?
Yes, Your Honor.
States Exhibit 1. Part of the record for all purposes. Pre-sentence report is waived here? Yes, Judge. I will follow this agreement. It says do not disturb us on. What's that? Okay, I'm not going to ask. The machine, it's always an adventure. You're pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes,
Even though there's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, the court is going to defer any finding of guilt, place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You must pay restitution to the victim in this case in the amount of $5,200. It's going to be the complainant who's named in the indictment. Is that right? And you must attend and complete theft prevention class. And there are a bunch of there's like 35 conditions, but the overwhelming majority I've got to follow. It's the same kind of things. It's, don't get in trouble.
Okay.
And I'm going to pass this over to the probation office. Please review it, sign it, and begin probation and be successful.
Great. Thank you.
Thank you, sir.
Alrighty, friends, let's stay in Texas, but we'll go back down to Judge Boyd.
You in agreement to early term?
Judge, we're going to be withdrawing that motion for early termination.
Okay. All right. So. Okay. Thank you. We're going to go on the record. Court is calling 2022 CR 10840 State versus Jerry Castillo Jr. Can I have parties announced for the record?
Opinion for the state of Texas.
Peter Calderola for Mr. Castillo, Your Honor.
All right. Are you Mr. Castillo?
Yes, Your Honor.
All right. So defense is the court's understanding that you're withdrawing your motion for request for early termination?
That's correct, Your Honor.
And I'm assuming there are no objections? All right, so now the other issue we have is the GPS.
That's correct.
So how are we going to address that?
Judge, part of the concerns, I think, with probation set this hearing for GPS fees, Mr. Castillo has had trouble being able to afford those fees and fines. He's had his monitor calibrated 4 times, and he's also had it replaced 3. Today, I think we're just here to address some of those concerns that probation had with the court, Judge.
Okay.
Yes, ma'am. So as my attorney said, I've had multiple issues with this GPS as far as the
maintaining it, and I haven't been doing anything different. I've been staying out of the areas that I'm supposed to be avoiding, and that's always on my mind and making sure that I'm never violating in that part. But as far as the device and the physical components that make it up, those have been issues that I've had that were not in my control. And every time they were addressed to me, I made sure and went down and had them fixed or replaced by the RMS company.
Okay.
And with the fees, Your Honor, I've put probation first for the past 2-3 years, first before everything, before my kids, before my family, before my job. And there was a time last year when my hours got cut at work and I started to fall behind on my probation. I'm sorry, my GPS fees, yes. And upon falling behind, I started to think maybe I could get an early termination or file for it to get off. And just in those months, I started to fall behind, and that's how I got to where I am.
Okay. So are your work hours back up or no?
No, they're not. They're still been cut, yes.
Okay.
I'm working between 25 to maybe 30, 32 hours a week.
Okay.
And I don't know. It's been hard because I've never been in this situation. I've always had a full-time job, even overtime hours. This is the first time actually in my life that I'm working so little hours. So it's a little bit of a struggle, financially and mentally, but that's the reality I'm living in right now.
Nothing further. We defer to the discretion of the court, Your Honor.
All right. So unless the state is in agreement, you have to remain on GPS. And I will tell you, it's the nature of the offense. Because with regards to your offense, it's because a previous court gave you instructions, like there were orders in place and you didn't follow them. And so, yes, sometimes people have actually been rehabilitated. And they're saying, you know what, I haven't been in this area because I'm not allowed to. But then people will say, well, you haven't been in that area because you have the GPS and it'll tell us if you're in that area. So, counsel, you may want to call the company and see if they will accept payments.
Yes, Your Honor. I'd just like to note, Your Honor, initially you put the GPS on me for only a year into my probation. And at this moment, I'm on GPS strictly because I picked up new charges, I think last year. And I've already settled those charges. I satisfied the probation and I've completed those entire charges. And the only reason I'm on the monitor now is because you put it until further notice.
Yeah.
Yeah.
And the reason why you're on the monitor, because
I understand what you just said.
yes. So, and picked up new charges. Okay. So that's where we are. And I always tell people in life, there are consequences for actions. And I understand that you're understanding that now, that there are consequences. Sometimes people go through life and nobody gives them any consequences for their actions. So when they become adults, they're like, I'm not supposed to get consequences. So this is where we are. I will tell you though, I do internalize what you're saying, and I know that that is a hefty fee. My understanding is there is a monitor somewhere that is a monitor for free that the company is supposed to have. And I have yet to see it. I don't know who's on that monitor where they are free. You may want to talk to the company and say, my understanding, you're supposed to have at least one free monitor. Who has this one free monitor? Because I have yet to see it. But if you'll speak with them and see maybe if they can work out an installment plan for him. If they cannot, you come back and we'll see what we can do.
I'll inquire, Your Honor.
All right. Thank you so much. And thank you. You're always dressed appropriately for court. I really do appreciate it.
Always need this.
All right.
May we excuse, Judge?
Yes. Thank you so much.
Thank you.
Who's next?
Wait, the dog, here, wait, over the dog. Marcus Romero?
Marcus Romero? Yeah, we've already done the plea.
Okay. Esther de la Fuente, the plea.
I think they're working on
Right
the,
here.
okay.
All right, friends, apologies for an awkward few moments there. I told you I would get called away, and I did, because, again, I've got people here working on stuff. But we're just about to the end of fourth hour. It's a good place to call it for today. I'll be back tomorrow, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour early for channel members. If you're not a channel member, consider fixing that. It's $2.99 a month. We don't charge a lot there because the goal is not to make a ton of money on that as much as it's just to have a little bit of a barrier to entry to keep it a little more of a tight-knit community. But on the pre-show, we've been having a lot of fun lately, doing a lot of humorful things. So it's a good way to start the day, so consider that. And please do join us in the blind tonight, 7 a.m. Eastern, 4 p.m. Pacific. There's a link in the pinned chat. Please do check that out. Mike and I are really excited. Michael Groff joins me on that show. He is our official Arizona weatherman and official TCF weatherman, and he is the guest host when I'm not here. Sidebar panelist, you see him all the time. And we're really excited. The whole thing with In the Blind is we have no idea what we're going to talk about until the show starts and it's presented to us. So it makes it a hoot. So be sure to check that out tonight. In the meantime, go have yourselves a good day, and I'll see you all tomorrow and hopefully see you all tonight as well. Take care. God bless.